Stories gotta collide, alibis get swept aside. I got proof that can't be denied. The data don't lie, people do. Waves crashing, secrets in the tide. Facts and numbers side by side. Through the chaos I will abide. The data don't lie, people do. Look at the records, feel the vibe. Digits and bytes come alive. I stand tall with nothing to hide. The data don't lie, people do. May twist and tongues may tie. Plausible tales shape the sky. In the end you can verify. The data don't lie, people do. It's in the matrix beyond the eye. Hard truth that's flying by. Evidence you can't defy. The data don't lie, people do. Look at the records, feel the vibe. Digits and bytes come alive. I stand tall with nothing to hide. The data don't lie, people do. Digits and bytes come alive. I stand tall with nothing to hide. The data don't lie, people do.
Hello everyone. I decided to have a vent. Stuff is going on. You know what I think's happening? I think we have a verdict. Just reading into it. Let me share this other screen. And I thought maybe we should watch this together because I think we're there. Because the questions that they're asking are about the OUI charge. I'm so proud of them I am so proud of this jury because they picked up on the issue that I was pointing out yesterday. They're worried that the OUI lesser is bundled under charge 2 manslaughter. That's what they're worried about, and she's refusing to clarify for them. So that's an issue for the jury, obviously, but I think that's good for us. I think we're going to get a not guilty out of this because if she refuses to answer a second time, which it looks like she's going to, then she's not answering their question. They're just going to give her not guilty across the board. She's kind of, well, like Bev always does, chopping her nose off to spite her face, isn't she? Corn Pope says, Hank Brennan is giving Elaine Bredehoff energy. How embarrassing. Indeed. Indeed it is embarrassing. So I don't know what we do here. Like, I wanted to just go back and sort of replay what happened, but I feel like when we do go back to replay what happened, we're going to end up missing what's going to happen. Where are we? Here. So maybe someone can keep an eye out. I hope not guilty. Yes, I think it will be. I think we're getting there. I'm going to go back, but someone needs to keep an eye out and tell me if we're missing something if I do go back and replay this. But I just wanted to play it through so you understand where I'm coming from. Okay. unless he's getting all his appeal issues in order. This is probably the hardest part because they've got to do this all ad lib.
That's pretty clear cut what they're looking for.
Hang on, let's go back.
Survey.
All right.
Counsel, what I'd like to do is I'm just going to read the questions to you now, so please take your seats. So I'm going to read the questions. I'm going to have them marked. Then I will take a short recess, let you all talk about it, and then come back.
Thank you.
So, all right. So I received 3 questions from the jury. The
That's
first
what
one
we're
is,
for.
they appeared on note cards, so that I don't know what order they came in, but this is the order I got them. This is the order I'm going to read them. What is the time frame for the OUI charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.?
Great question.
The
These guys
second
are thinking
are
on
video
their toes.
clips of Karen's interviews evidence. How can we consider them? And the third, does convicting guilty on a subcharge, example offense 2 number 5, convict the overall charge? So
Pretty an
I will
awesome
give you some
question.
time to consult. I think the first one, I'll hear from you as to what the time frame is, and I don't need to hear from you now. That's pretty clear cut what they're looking for. The second one are video clips of Karen's interviews evidence. How can we consider them? Well, we know they are evidence and they can give them whatever weight they want. I would also be inclined to give a humane practice instruction, and tell me if you want the digital evidence instruction. It's a little awkward because it would be something like, before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the person who appeared in the communication
She'll
was
give
in fact
pages
Karen
all
Reed.
that.
So think about that when I come back out. But I think it's appropriate to give a humane practice instruction, and also tell me what you think about what to say about the weight. The third question is a little bit more, I think, unclear as to exactly what they're looking for. Does convicting guilty on a subcharge, example offense 2 number 5, convict the overall charge? What I'm proposing.
Oh my God, Bev. Question 2 and question 3 are the same fucking question. She's a little awkward, right? They're asking the same question. They're worried about what I pointed out yesterday. She has bundled the OUI in with charge 2 manslaughter. So I am so proud of the jury for picking up on this. 2 of their questions at the start of this, I think this was before lunch, 2 of their questions are related to what I pointed out yesterday. And I'm so surprised. I'm proud of them, but I'm also really surprised that they picked up on it. So she decides not to answer them. She just basically repeats her funneling question. This is how I told you to funnel it, and you've got to funnel it this way. That's basically what she comes up with at the end of this. But what happens then is, I don't think we need to be frustrated listening to her tell them that, but they come back with another question. I think this is it here. Oh, this might be where she's going to read it to them, actually. We'll work out which bit this is.
All right, so I will hear you on the first question, the time of the OUI. Any suggestions?
Your Honor, do you want to hear from the defense first?
I'll hear from whoever's.
She basically just ignores everything the defense says. But
Remember, you are the fact finders.
she also tells the jury. She also tells Brennan to sit the fuck down and shut the fuck up. So that's a great thing. So then they come, because she doesn't answer their question, she just reiterates her jury instructions, her funneling instructions, how to funnel down through that specific charge, because it's the only one with all the lessers. They send her another note back asking the same question again. So the last two questions were basically, we don't want to charge her for manslaughter, but OUI, we're happy to give her the OUI. And she's still saying no. So I'm not going to answer that question. So they come back with the same question, just asked a little differently. No, you hear they're checking the form. Checking the form, and then she reads it to them. So we must be here for another question. Because they're not taking her bullshit. They're like, you didn't answer our question. She is indeed the new C word. So, yeah, sidebar. Sidebar. All right. We've got the screaming wheel of death here. Give me 1 second. So essentially, the jury comes back and says, you didn't answer our question, Bevy. Here we go.
Please be seated. Court is in session.
All right, so I'll see you at Sidebar so we don't do this part in open court.
So that the public can't hear this part in court. And then she completely misconstrues what the defense says to answer in this one.
All right, so as counsel knows, we received a question from the jurors. If we find not guilty on 2 charges but can't agree on 1 charge, is it a hung jury on all 3 charges or just 1 charge? I got some input from the defense at Sidebar, essentially saying if we could just ignore it. We can't ignore it. To me, it's a theoretical question.
No, it's not, Bev.
And we don't answer theoretical questions. I tell the jurors that they're
No, it's
not
not.
to be concerned with the consequences of their verdict, and that's exactly what they're doing here. So I would propose just writing simply, this is not a question I can answer on this, and sending it back.
The defense position is not, certainly not the question for it. I agree, you can't ignore it to your question. However, I think that it is apropos, given the timing of when that question came in, literally before the court had answered the other 3 note card questions. I think that it would be appropriate to send a quick note just asking them, given the fact that there's some clarity in your other questions, does this answer your question? In other words, can you proceed without any further input?
Yeah, she didn't answer the question before, and she should ask them.
So that made sense initially, but why ask them, do I really need to answer it, to then tell them I'm not answering it?
Because I think at some point, they need to know what the law is. It's a reporting question.
It's a legal question.
I don't see it as theoretical, as the court indicated. I see it a little bit differently, which is what are our options? And the options are built in the law, not in theory. If they come back with a verdict on more than 1 count, but they're hung on a separate count, they are to report those 2 counts, whatever counts they came to a verdict on.
So that's for a later time.
Shut up, Bev. Let me just explain what Jackson's saying here. The jury's asking a basic question about legal cause and the charge hierarchy. All 3 questions, aside of, what time of day was the actual DUI part, all 3 other questions were about the hierarchy of the charges. Those are not theoretical. Those are questions about legal cause and the charge hierarchy. And it's her job to answer that. She's trying not to answer that because she doesn't want them to come to what we're all assuming they've come to, and that's just, well, here's a split the baby charge, we'll give her OUI. So interesting, but Jackson's arguing the exact correct argument here.
Right? So this is at this point.
Right.
It's premature, it's hypothetical, it's theoretical. I understand your point. I think I disagree with you at this point. It may be something later. The way the question's worded, if I find this, if we do this. I'll hear from the Commonwealth.
We agree it's consequence related. Your first suggestion, I think, is most appropriate, and we would endorse that.
Yeah. I'm going to do that at this time, Mr. Jackson. I'm not going to have a back and forth with them. I'm simply going to say, because it's true, it's the law, that this is not a question I can answer.
But I would
It
strongly
is.
suggest we find some other way. If that question
Answer them,
continues
Bev.
to remain, then they're not going to ask that question. I don't think the court can say,
Michelle.
I can't answer the question, because the court can answer that question.
It's
The
your
court absolutely
court's
can answer.
job
I would
to
simply
answer
say,
that question.
this question is not before the court without further information, or something like that. Not the court can't answer that question, because if that question remains in their minds, we're going to end up in the exact same position that we were in last year.
There are other steps that can be taken to perhaps prevent that. What do you
Whatever
say?
those steps are, I think the first step down the wrong path is to say, throw our hands up and say, well, we can't answer that question. Well, we know we can answer it.
So I don't know if I want to put you in an uncomfortable position, Ms. Giannetti. I'm inclined to answer the question the way I stated.
Could we have 2 minutes to confer with counsel, Your Honor?
No,
How
you
about
can't.
1 minute? You guys are 10 minutes late.
We just need 1 minute.
Right. So that's what she decided. I'm not going to answer the question. Sorry. So we must be still sitting on the fan. All right. That's good. That brings us up to date. So essentially, Jackson's on the right path. She can answer the question. They're not asking about theoretical how they should answer something. They're asking about questions of law. The legal cause and charge hierarchy. Now, she could have avoided this by going with the jury form that the defense team submitted yesterday and said, let's put that charge by itself on its own as its own charge. And she went, no, I'm not doing that. So now she's back here not answering the jury's question. You can tell that they're frustrated that she didn't answer it the first time, because they essentially came back and reworded the question to sort of be more clear about what it was that they were asking. And she's still not going to answer them. And that's why I think we're going to end up with not guilty. If she can't be clear about how they should fill out the form, they're just going to be not guilty across the whole lot. That's what I think is going on. Could be wrong, but that's my guess. It seems to me like she hasn't answered them. Sit the fuck down, Jackson, because if she doesn't answer them, they don't get an answer. They just go not guilty across the board. That's what I think. I think that's a bonus. Just zip it. Don't argue anymore. Let it go. Shell's at work. Thanks for dropping in anyway. But don't scream at work, please. They were 10 minutes late. Yeah, I know. It takes them 10 minutes to get past the fucking crowd out the front, for fuck's sake. So she's like, you can go away for 10 minutes, but you need to be back here right on that 10 minutes. But it takes them 10 minutes just to get out the fucking door. So anyway. Oh my God, she's so frustrating. I think I get where the defense is worried. Someone said something about a hot mic where Alan Jackson said, I can't do this again. I'm pretty sure they all feel like they can't do this again. But I actually think Bev not answering them is a bonus, because they're already showing they're frustrated. Larry Foreman, if we get a verdict at 227, I'm going to lose it. They were back, right? She was the one that friggin' called a sidebar and wasted that 10 minutes, right? And then she turns around and says, oh, you just instructed me to ignore the jury. And that's not what he said at all. So he got all that on the record. But here's the thing. even though I'm saying sit down and don't say anything, that's kind of what got them in this mess to begin with last trial. So I'm glad they are saying something and they're getting shit on the record. Everything she's doing is over and above his objections. He's getting it on the record. That's great. And whatever happens from here, Bev thought she had this cooked when she cooked up this funnel jury form. But everything she's done since then, she's fucked it all up because she's making rulings that are not consistent with the law. So she's opening back up all these possibilities for appeals again. I think she's tripping over her own feet here. So if Canoni was doing her job, she would say, and she is entitled to say as the judge, no, a guilty verdict on count 5 does not automatically result in guilt on charge 2. But she won't say that because she specifically put it under charge 2, so it could be. She could say each charge requires independent agreement on its specific elements. She could say a verdict of guilty on the lesser does not imply guilt on the greater, but she won't because that was the point of putting it there under charge 2. You are all free to find guilt or not guilt on any charge provided you are unanimous. Those are all things that she could say to the jury because she's the judge and she's supposed to say to the jury, but instead she's allowing the jury to worry that their intent might be misapplied, which is what happened in trial 1.0. So she's essentially baiting them into an unintended manslaughter conviction. That's what she's doing here. So we can all see it. Right, he did say that they're not going anywhere. That's right. I know that they're all holding their head in their hands going, God, I can't do this again. They know because the Commonwealth have already come out and said, if it's a hung jury, we're going to retry her. So what they hang on is important right now. If they only hang on OUI and they acquit her on everything else, then we're good because the Commonwealth can only retry her on OUI. They can't retry her on or the manslaughter and all the other charges. So I believe they're not going to give up. But I do believe that, they're all fucking tired of this bullshit. We all are. Yes, the world's watching, Bevy. The whole world is watching. Biatch. Anyway, let's go back through the rest of the notes that I wrote on this. Dudes, I woke up at like 3:30 a.m. and went live 10 minutes later. So I'm still on my first coffee. I've written a billion freaking notes already. I just woke up and I was like already freaking annoyed and already like scribbling. Anyway, Jackson's preserving the record. So whatever she does from here, it's preserved on the record. He's saying it's over and above his objection. That's great. He's forcing the court to own its own actions here. And it's brilliant because even if a compromise verdict does happen, he just sealed another appellate issue where she was trying to seal him out of appellate issues. He's caught her in an appellate issue right here. So that's why he's being adamant. I got caught in a call and missed everything. Oh, damn, you're going to have to rewind. Basically, the last 3 questions, out of 4 questions, the jury has asked 3 of them about OUI, and she's not answering them. So that's the bottom line, Cornpote. If she doesn't answer them, then they just go not guilty. We don't get a straight answer out of the judge, so we're not taking the chance of her misapplying our verdict. I think this is great. This is more consideration than the last jury ever gave any of these convictions. So it's freaking brilliant. I love it. I love where it's going. I love what Jackson's doing, getting all on the record, because where she thought she had sealed them out of any kind of appeal, she thought she was cutting their knees off with the 60 odd freaking paths of error that we already recorded from trial 1 to trial 2. by adding this OUI into that second column, into that second charge. And since then, she kind of did, but since then, she's opened up other appeals. So she's being a dickhead and cutting her own nose off to spite her face now. So if it's hung, they need to move heaven and hell to get Bev off this case. So I don't know. I don't know. How silly is it that if they took the defense suggestion of a jury form, they wouldn't need to ask exactly, Cornpope? Exactly. It needed to be a separate charge. That's 3 questions the jury wouldn't have asked. One question they would have come back with was, is the OUI applicable to the 1245 or is it applicable to the 507? Which one was she drink driving for? But the charge, the indictment sheet doesn't say what time. It just says the day. It just says that on the 29th she was charged with murder. It doesn't say what time she was charged with drink driving. In fact, I don't think she was ever charged with drink driving. It was never a charge that was added for this. I also found out that it actually was the defense that asked for it. I was very confused, and yesterday before Jason jumped on, I was going to go back over that footage, court footage, to find out how that went down and who it was that asked for it and what it was that Bev said she was doing her way anyway. So I think it was Karen decided she wanted it. I don't know that her lawyers agreed with that, but I think Karen decided she wanted it because she can't go through this again. So she wanted to give them a split the baby kind of verdict. And then Bev said, well, I'm sticking it under the lesser includeds, but that's not what the defense was asking for. So that's where I got confused. She was like, she didn't just sua sponte say, I'm going to add this charge. They asked for it, but where it was put on the form was Bev fucking them around. So, and now you've got the jury going, yeah, you're fucking us around. Yeah, what's the uncomfortable position? Can it be an uncomfortable position? Exactly. So, what else have I got in my notes here? So if we get a guilty verdict now, because of what's just unfolded now, the defense can absolutely appeal and argue that it was a product of jury confusion and judicial dereliction of duty and structural reversible error under the 6th and 14th Amendments. That's, I think, due process and I forget what the other one is. So basically, she just fucked up big time is the bottom line. The way she was going about it, she was heading towards cutting them off. Now she's fucked up doubly. So, which is pretty funny because it's what she keeps doing, right? She keeps thinking, yeah, I'm so fucking clever, so I'm going to do X, Y, and Z. And then she gets fucking caught out and then undoes her own fucking plan. So this is what they all been doing. Jennifer McCabe did the same fucking thing. She got caught out, undid her plan. Kerry Roberts, she got caught out, undid her plan. Everybody seems to be like, they got these master fucking plans and then they get caught out and then they fuck themselves up even harder in trying to cover up their fucking plans. So she's never charged with DUI, no vehicle accident report. The BAC is not on a report to be used in court, etc., etc. You're correct. You're exactly correct. Joanna from Canton is with us. How's it going? Is everyone on the edge of their seats over there? Holy shit, I don't even know how you guys are dealing with this today. Like crazy town. I got Melanie on that and you on my phone. Good on you, Donna. Good on you. And Gabby's in the house. Sorry, I did this all very last minute and didn't let my mods know. Sorry, mods. Like I said, I just woke up, scribbled out some notes, and went, "Oh my God, we've got to." I think we're going to have a not guilty. I think we're going to have a verdict before the day is over, as long as Judge Bev doesn't chuck a freaking "I need a white claw" at the fucking Cape tantrum. So long as she doesn't do that, I think we're going to have a verdict by the end of the day. So we were talking about this last night, weren't we? We were, Joanna. This is exactly what we were talking about, and I am so glad that the jury picked it up. Like, how good is it? We're sitting here yesterday talking about exactly this, where she put that OUI on the form, and the jury picked up on it. So fucking pleased. Like, I feel 1,000% more confident in this jury than jury 1.0 because they're asking the right questions, right? Sorry, Joanna, Boston area, not Canton. Thank you. But yeah, I'm sure yous are all on the edge of your seats, right? I know yous are. But yeah, crazy how we were just talking about it yesterday, and the jury's onto it. I'm so stoked. I'm so proud of this jury. So proud. And like, I was a little worried that she did the whole, "You reckon not guilty on all three?" Me too. Corn Pope, I really want the verdict at 2:27. Oh my God, that would just be poetic, wouldn't it? Larry's gonna fucking fall off his chair. Everyone's saying it though. Everyone is saying it. I mean, it truly would be poetic. So, should we current state of affairs? Everyone's just sitting there with their hands on their heads at the moment. What is going on? All right, I'm just thinking who we should tune into. Oh my God, this one. Let's tune into this. I'll put the Only fan in the background. So you know how Michael Easter never got to testify? So he was going to testify to he was going to testify to the procedure of a murder investigation, like the policies and procedures that he teaches as I think it's across the board, but anyway, let's tune in. I'll put the Only fan in the background. Yes, me too. I think so. I think we're going to. That's why I kicked off a live stream at the last second. So let's put Only fan in the background and go get Michael Easter talking about. There's not a lot he could tell us. It wasn't as informative as I would like to have been. But it tells us, what he was going to testify to, sort of broadly. So let me get it up here. Where is it? Oh, did she do it? Stream it as a live. This one here. Here we go. Let's get this up on here and listen to Michael Easter. So he's on Justice Served. Did an interview with them. Let's get over there. Skip the ad. Get us back to the start. Another fucking ad. Yeah, I know. I should get premium.
From my more kind of natural expertise, which is the historical cell phone records and other patient records. And that's where Attorney Jackson reached out to me originally. And as part of that, I've testified as an expert in over 200 trials, both federal and state. Clearly, I'm now retired and I do stuff privately. But when I started interacting with Alan on the case, I started asking questions that I would naturally ask about the investigation. How do we look at the phone records? How did the government look at the phone records? How do we incorporate them into the investigation and the defense case in chief? Where does the evidence put this? And as I asked more questions were not answered. And simple questions about, well, whose phone records are we looking at? Where's the victim's phone records? Where are the other suspect phone records? None of these things existed. And as the conversation sort of evolved, Alan's like, Mike, would you mind just looking at the evidence from your investigative perspective? And for that, I spent over 20 years with the FBI as an.
Before he goes on, let me just say that's exactly what I've been saying all along. Those records never existed. What they got was spreadsheets that someone else made, supposedly from John and Karen's records, but nobody actually saw the records. And that's exactly what he just finished saying. He's showing these spreadsheets. He's going, yeah, that's not a Celebrite report. That's someone's spreadsheet. We can't rely on that. So fucking awesome. So glad he picked up on that, and so glad that he pointed it out, because it's what I've been saying. We can't rely on any of their spreadsheet data because it's not the Cellbrite records. But he says more about the Cellbrite records. So
An investigator. I was a law enforcement officer prior to that, and formerly a Marine officer as well. And as he asked, I said, you know what, I'd love to look at the case. Can I get access to the discovery? And so at that point, I looked at the discovery material provided by the Commonwealth, not only with the idea of looking at the phone records clearly, which was the initial aspect, but as a fellow investigator, what would I have done? How would I have looked at this case? And what are some logical steps that I would have taken along the way? And did those logical steps take place? And maybe I'll add to that last aspect was, in that review, my focus wasn't just on what evidence they collected or didn't collect in those steps, but what is the Massachusetts State Police policy? What does it say they should have done? And that policy guide is actually online. And I looked at that and made a comparative assessment of what did the Massachusetts State Police do? Is that the best practice? And is it consistent or inconsistent with their own policy guide? And then I drafted a report and provided that to the court. And I think you mentioned it, and maybe somewhat now, Mr. Jackson's "do it" comment had made it to the interweb. So yeah, that's maybe start there for you. And I don't know if that answers questions or creates more, but
I didn't realize that that's how it evolved. You know, I thought it was from the start. You know, let's look at this investigation. I've looked at your CV, so I did know that it was cell phone and that kind of data intensive, right?
Right.
So, Mr. Easter, can you tell this jury what your ultimate opinion is as to how the investigation was carried out in this case?
Yeah, I can. Well, maybe the jury's not listening, hopefully, but at least the people on your channel. So for the Bureau, I also was an instructor. And one of the things I always teach is process. Have a process to dissect the problem. And when I looked at this, I really came up with three kind of words to sort of encapsulate the investigation or the lack thereof. And the first one was, I found that the investigation was incomplete. And incomplete in the logical steps you would take to determine whether Karen Reed was the suspect or other people were the suspect. Not following logical investigative steps to collect evidence, to preserve evidence correctly. We can always look back to the crime scene. But even beyond that, as the case migrated throughout that day, and how quickly and even prematurely they identified Karen Reed as the sole suspect. So the first word is incomplete. Incomplete investigations in turn birth out this next word, which I think of as an easy way to look at it would be inconsistencies. And maybe I'll stick with I's. Is that an incomplete investigation creates inconsistencies, and those inconsistencies can show up in time typically, and you saw it in this case. This case was riddled with timeline issues.
Yep.
And that's because they never completed proper investigative steps to collect CCTV along likely routes of travel to and from, which they should have done. They should have traced those things. You saw in the testimony of, I think, Walt.
Let me just say he's being far too kind. It was bogus timestamps is what it was. But we'll go with inconsistent.
Culture tried to show some Google Maps, which is a great technique. I use it, which is use routes that the phone or the person could have taken, and then tracing those routes for CCTV, whether those are ring cameras, business cameras, or static cameras, to see if we can develop a timeline and a route of travel for Karen Reed's vehicle or someone else that could have been there. And then an inconsistency, it breeds the follow-on, and which is another I word. Maybe I should have coined all these, but is inaccuracies. Incomplete, inconsistent, all ends up with inaccuracies, and you see it. Now we have all these inaccuracies in the case that makes you start scratching your head. Why don't any of these things add up?
Yep.
Why do we have so many things that conflict with each other?
Yep.
And the reason that happens is it happens because the investigator had all three of those eyes. Their process was flawed from the beginning. And it, you know, I get the question from people that know I was assisting, which is, Mike, what do you think? Are they biased? Is it corruption? And that's a really hard question to answer. And the reason I say that is I've worked cases all over the country. I've worked cases in Central and South America and parts of Europe. And I've seen corruption. And I've seen cases that are also worked by people that are just poorly trained and have no experience. And the problem is corruption, inexperience, and no training, they end up looking very similar in the result. And the problem with that then is, how do you determine corruption versus incompetence?
Well done, Michelle. Another eye.
And that really then becomes a hard decision for the trier of facts. I think ultimately, my opinion is that I don't have one, whether it was corruption or incompetence or experience. I think the results speak from the South that the investigators lack the training and experience necessary to have a complete, thorough, and accurate investigation.
Oh, I did that just in time. He is being far too kind, but I get it, because like, dude's got to still work, you know, afterwards. Does it need to be called out afterwards? Idiotic. Michelle's still going with the I words. So he's being far too kind. I believe it was weaponized incompetence, inept. Kevin's going. So we've got incomplete, inconsistent, inaccurate, imbecilic, idiotic, inept. Oops, that was 6, right? So yeah, I agree with you guys. But he is being far too kind, and this is the thing that pisses me off when people won't just say it outright. This is called weaponized incompetence. That's what I thought. Hey, that was another I word. Incompetence. There you go. We're going hard on the eyes. There was too many eyes to describe it. But yeah, just they haven't been trained. Come on, these people had 20 years training in murder, and look at the murder investigations that they did do. You know, way back in the early days, Microdots did a video on an investigation that I think it was like Tully, Proctor, and I forget who else. Another murder investigation in like one township over. I cannot remember the exact details, but we can probably play through that. But they actually did do a really good job at solving that murder investigation. It was someone got shot. They had a crime taped off. They had evidence markers for everything. Like, you can't tell me that they all of a sudden became less trained because it was another one. You can't all of a sudden tell me that they became suddenly less trained just because it was Karen Reed or because it was Officer O'Keefe. But anyway, he's being way too.
I'm just blown. I'm writing this down. I'm just blown away with what kind of testimony Mike Easter would have given, and just the presentation, and just this little thumbnail sketch we have of having it incomplete, inconsistent, and inaccurate, leading to it could be incompetence, it could be bias, it could be anything, but it's the same result. I'm just blown away by the whole thematic approach And so, Mike, what would you say? I'm sure you had. I always have like a rule of threes. Was the three worst things that you saw that were not done? If I'm phrasing that correctly.
So that's a really good question. I think the worst thing that was done from the beginning was the response. And that's what struck me the most. Everyone focuses on the investigation and the outcome of the investigation. As a former law enforcement officer, I've responded to dozens of OIS, or officer involved shootings. And I can tell you that the response is overwhelming. We don't have to beg people to come in and help find the suspect. In fact, we spend more time telling people to not come in, go home, get some sleep, come back later. When I looked at this case, my first law enforcement reaction was, why didn't anybody show up? Why didn't everybody show up? I would have walked in the snow to go help in this case. I've had agents that have been shot. I've had fellow law enforcement officers that I worked a lot with LAPD. A young LAPD officer I recall getting killed trying to stop just a graffiti incident late at night, brand new rookie cop, and made the decision to try to make a difference and paid his life for it. And the response was overwhelming, right? When you look at this, do you feel you get a response or an idea that the response from law enforcement was overwhelming? No, I didn't. In fact, at times I thought, why? What's going on over there in Massachusetts that we don't see this response? I always thought Boston, the old saying, blue was blue. I didn't see it in this case. Didn't, at least not in the way I would hope to have seen it, which is everybody showing up and not having to be sent home. Did you want to respond to that? I'll give you a second one, or you can respond.
No. Please give us a second one. This is fascinating. It's wonderful listening to you.
Sorry, guys. So we're up to 10 I words now. Let's do them all. We have incomplete, inconsistent, inaccurate. Those were all his kind words. But we also have imbecilic, idiotic, inept, incompetent, irregular, imbalanced, injustice, irresponsible. Like, how many I words can we come up with? I can tell you what they didn't do, their jobs. Exactly. Yep. We're cruising. Whoops.
That was what we see in the investigation. So then we have to take a step back. And the step back, the thing that I thought was most interesting was the lack of training. And that is a cultural problem. Their style of policing, the way they respond to this, reminds me of what I used to see about 20 years ago when I first came in.
Keystone Cops.
This sort of shoot from the hip, gunslinger kind of, our word is our bond. We just do what we do. This is how we do it. And it bore out in the response. We see a leaf blower, we see solo cups, we see a shopping bag. We see no chain of evidence. Think of the chain of evidence that wasn't collected at the crime. So we see no preservation of the crime scene. And instead, we see an abandonment of it. It was never secured. No proper collection of evidence. There was never even a sketch or diagram done that anybody could go back and piece back the crime scene itself. Instead, we have to rely on some really blurry dash cam video to try to piece together where Mr. O'Keefe finally laid to rest, right? That's horrible. I mean, no one, the first thing you learn at responding to a crime scene is secure this crime scene, identify witnesses and suspects, separate them, do a safety sweep. I mean, you have a dead person on the lawn. What's the possibility the suspect's still present or other victims are present, not just on the lawn, but in the property itself? So that second part is cultural. It's a training issue. And I think you'll see Massachusetts State Police and Canton Police PD have a huge cultural shift from this, and maybe that'll be the biggest thing that the city of Canton or that area will see, is a culture in the policing process. At least I would hope. And then my third one is
there's a fourth question. I'm still looking at the fan. Where did the fourth question come from? Yeah, I'm still looking at the fan here. Glen Lake with the double eyes, invoking irateness. Michelle, incomprehensible. I'm not seeing it on Channel 10 yet. Where did you see this, Corn Pope? I'm just looking. Sorry, guys, I went quiet on you. If we find guilty on 2 charges, that's from law and crime. Yeah, I'm not seeing another question. Are you sure you're not repeating the one? Right, so the first 3 questions were what time in the, was it 12:45 or 5 a.m. for the OUI? And then there 2 follow-up questions from that were about the OUI. And then she didn't answer them. She come back with the 4th question. They're still saying about the OUI because they want to acquit her on everything except the OUI, and it doesn't look like that on the form. So I think we actually did. I think we actually did go through. You just might not have been here, but that was at the start. So
the investigative process itself, it lacked a process. And that was the most surprising thing to me. That listen, I will give them this, is that having worked these types of critical incidences, the pressure, not just from the victim family, from your peers as you work this, but management, even elected officials. I've worked some of the biggest cases in the country, and the pressure that you get to solve that thing before people break for the day. They want hourly briefings. The investigators are under enormous pressure to solve that problem very quickly. And that's where the investigative process has to remain consistent. You can't start taking shortcuts. You can't leapfrog investigative steps and get to an ultimate conclusion too prematurely. Or oftentimes what happens is you miss evidence you should have collected. You eliminate people that could have been suspect or should have been suspects, and you sort of fall in love with the suspect too soon and get vapor lock, or which, a lot of people say confirmation bias, that's the person. We're going to prove they did it, and I want it done by 2 p.m. Or some heads are going to roll. That's sort of, those would be my 3 things on it. I hopefully maybe didn't spend too much time on them for you.
No,
it's amazing. Let me ask this as a follow-up, because I think if you were to testify, it would have come up. People are pointing out the fact that maybe it wasn't so shocking that the response to a officer down, in the circumstance where you have other officers involved, as in, I don't know, the homeowner and some of the others involved in the investigation. Did that play into your analysis at all? That there may have been
question,
not just
Michael.
Let's take care of the officer down, but let's protect the other officers who might be involved.
Yeah. Go away with the ads.
I think it's a reasonable question. I don't think that is a reasonable reason, though. And I don't think it was ultimately the reason. I think, let's just say your argument's true. I still would have expected a large response, not to hide, but to a large response and to huddle. And hey, what are we going to do with this situation? And some very in these big incidences, there should always be a big command incident. There should have been a command incident commander, somebody in charge of the command, a response. There would be big type of group meetings.
Oh my God, Glenn Lake, you're breaking my brain now. Let me have 2 more coffees first. Well done. Irritating. We're still going with the eyes. I did cover all 4 of them. So go back to the start. I covered all 4 questions and why the 4th one came back the way it did, and why they worded it slightly differently. So go back to the start if you just want to recap.
And then there's the small group meeting. The very intimate people that are going to really solve this problem meet separately. And we would have seen those things.
Glenn, she's gonna poll him. She has no choice.
Correctly, even if, as you discussed, Michael, there is some, I don't want to say corruption, but a tendency to protect somebody. There would have still been a response, or we would have seen an enormous phone tree happening. Although we no that type of evidence was collected clearly, but I think ultimately that's where the other investigation that was happening was probably looking into.
And so I have a question. I just want to tell our viewers that we're going to hold your super chats. We're going to continue with Miss Easter without doing the super chats right now for the moment. The issue of the medical examiner, as you know, my husband is a forensic pathologist. The issue of the whole medical examiner and dissing her with regard to the injuries. What would be the proper response when you have a medical examiner who says, "Look, in the first 9 days, I've looked at everything you have. I don't find this a homicide. I don't find any injuries consistent with an automobile strike here." Where does that lead you? Does that lead you?
Before she finishes that question, I just wanted to let you know, for those who don't know, Linda Kenny Baden's husband is actually the coroner in Sandra Birchmore's case, who reassessed and decided that she had that broken bone in her throat. It's suggesting that she had been strangled and not manually strangled and not suicided. So it's a type of strangulation. It's a bone in the throat that only gets broken when you apply pressure a certain way, which would not have happened if she was dangling from that belt. So but that's who her husband is, just so you know. He's the coroner, or the ME in that case, who discovered that she was murdered.
To say, she's a whack job, or I mean, I know I know the answer to that because that's what was in the text. But where do you go if you want to continue investigating because you don't want to have either what you think may be her vapor lock or your vapor lock?
Yeah, I found you're talking about Scorty Bello.
Yes, Scorty Bello.
Yeah, I found her to be one of the most credible witnesses there. Her demeanor, her poise, her confidence, and the science. You hear the science is the science, right? It is what it is. I tend to look at things in my world of the data is the data. It tells the story. It doesn't have an opinion one side or the other. Sometimes it benefits you, sometimes it doesn't. In this instance, to really answer your question a little more fairly, is that that's the investigator's job, is to collect the evidence that proves the medical examiner wrong or allows them to make a more informed decision, right? That's where the see, when I look back at this, the investigation was over by what, 11 p.m. It never really got legs. And because of that, you even saw in the trials, both of them, that they're still trying to figure out mid-trial in both cases.
Cornpo, go back to the start. I played in court, the actual court, what the judge read out from the note cards, the questions from the note cards. So go back to the start. You can save yourself a whole lot of typing just by rewinding back to the start, because I did go over what the notes were that were sent to the judge, and she read them out in court.
What happened? Can we still collect some more or conduct more testing to try to bear out what really happened? And I guarantee if there's a third trial, there's more evidence that they're going to try to find. There'll be more testing. So this, in some respects, the case isn't done being investigated, and it shouldn't be. In my opinion, there's still some valuable evidence that's available that should be collected if they knew where to look.
Like what specifically?
Yeah, like what?
So I have a hot take.
Wow.
AI is not just a buzzword if you use Monday CRM.
I'm so glad you.
Like what?
I'm sort of reluctant to share, only because my job's not to help the prosecution collect
Okay,
new
fair,
evidence.
fair. That's fair. What does the issue of the whole FBI? The judge wouldn't allow me to hear that there's Department of Justice FBI involved in this investigation. Now, was there things that you saw that you were able to riff on in your report, even though you couldn't mention FBI, as to things that should have been done? I'm not sure if I'm phrasing that right.
Yeah, I understand your question. Maybe just understand what I did for them ultimately was that in review, I talked about those three things as I looked at the investigation itself and the discovery items, and took each item, looked at it for what it provided, its incompleteness, its inconsistencies, and its inaccuracies. And then I wrote a report that identified what they did, what I thought the best practice would have been. And then I showed what does that look like in comparison to their own policy guide. And I wrote an opinion that on those key elements. And I looked at crime scene response, crime scene management, documentation, investigative techniques or lack of investigative techniques that were used, the premature assignment of individuals at 34 Fairview as witnesses only and not as suspects, no chronological case file, no overarching, well-maintained case management from beginning to end. And ultimately, I think one of the critical flaws was no timeline. And you saw that now in those trials is that they couldn't put the time together, and they're doing it after the fact with these witnesses on the stand to try to make sense of time. Time is, when I teach process for the Bureau, especially like a kidnapping or abduction, homicide cases where I've worked, if you've seen them, clearly we all seen mass shootings. I was at the Vegas. I worked Paddock's phone for that case. The number one thing is time. We need to establish a time from beginning to end and see where the evidence fits in the timeline. And when it doesn't fit, we need to understand why. And that leads to follow-on investigation. Why doesn't this event fit in our timeline? Is our timeline off? Or is this event that somebody recollected off? And we need to reconcile those things before we get to trial.
Did we completely invent
You mentioned a couple of things that are super important. One is a drum I've been beating all along, which is at the end of a trial, if you don't know what the hell happened, how do you get beyond that to find any sort of guilt?
Right.
But you mentioned, and I'll be honest about this, I've been known to poo-poo the cell phone data and how accurate it is and how reliable it is. And I think sometimes it's hard for a jury to embrace it as well. So how do you get them to believe? And you talk about, timelines not syncing up. They've heard everything in this case about what the data tells them or doesn't tell them. How do you get a jury to follow that science and understand and believe it?
Right. You bring up a good point. I think it's important to make a distinction. When I say cell phone records, for me personally, I'm talking about the cell phone provider. And that would be Verizon, T-Mobile, AT&T, Sprint when they existed. I think in this case, the people kept referring to them as cell phone records, as the Celebrite or forensic extraction of the mobile devices themselves. Yep. I don't term those cell phone records. Those are a forensic extraction. Yep. Cell phone records I look at more separately from the provider. Yep. And the times that come from those phone records are easy to sync up because we know what controls time in the cellular network. It's the switch for Verizon, for example.
Exactly, Joanne.
And so chronologically, we see those time events established, and we can replicate those by reattaching to the network very easily. I completely agree with you, Michael, on the Celebrite stuff. I couldn't agree more. In fact, I find, and I don't want to poo-poo Celebrite because I think the tool is amazing, but it's amazing for a couple things. It's amazing for content, your call list, and like I would say searches of the internet. It's horrible, absolutely horrible at time. Yep. And it's horrible at time because every time I've worked a case, it's always the outlier. They're like, what happened at this time? I'm like, according to what? They're like, the forensic extraction. I'm like, okay, forget time when we look at Celebrite.
So essentially, yes, Sprint still exists, but the records don't. They flush the records every so often. They might be somewhere in backup. I think they have, don't know what the year span is in America or even per state, but here in Australia, they've got to keep them for 7 years. their backups, but they flush their live records and keep their backups for up to 7 years. That's the law in Australia. I don't know what it is over there, but he was saying that those cell phone records are now tied up in backups and not available to the defense anymore, or anyone to subpoena them anymore. So what he's basically saying here is that Celebrite is notoriously bad for the times, and the more accurate data comes from the actual phone company. And the reason is Celebrite is extracting from the phone what the phone was recording, what time was the phone set to. And as we found out during this trial, you got 3 different types of time inside your phone, inside your iPhone. You got monotonic, I forget what the other 2 are. Or one's GPS time and the other one's the world server time, I think. Those are the 3. And so what he's basically saying is, yeah, the phone has those recorded in it. So when you do a cell extraction, those are the times. It's one of those 3 times that you're getting out of the cell extraction by Celebrite. But if you go to Sprint, that is actually on a cloud, and that cloud is giving you one world server time, and that will be consistent from one record to the next. It will always be consistent. There's no user going in and saying, oh, that I need my phone to sync time to, my work clock, so I'm going to change it by 5 minutes or whatever. There's none of that interference that can come into it that a Celebrite extraction is going to show you. When you're working with Sprint or whoever the cell phone provider is, you end up with more accurate. It's not totally accurate. You're still going to have some type of drift, but at the same time, it's definitely more accurate because it's synced to a world clock, which all of our devices at some stage will sync to a world clock. But I can, go and manually change my time right now, even though I am synced to a world clock based on Sydney time. I can say, well, I want to be 10 minutes ahead so that I arrive at all of my meetings and shit 10 minutes early. You know what I'm saying? That's the difference between your Celebrite extraction, reading the time off your phone, and your record provider, your phone record provider, basically. But yeah, let's continue with that. That's basically why he's saying Celebrite's not entirely reliable for time, but it's great for content and context.
Let's just look at it for content. I think there's a lot of value, and we could probably have that discussion separately, but time from Celebrite or any other forensic extraction tool, I do not put a lot of weight on it. Instead, I look at it and, okay, where did you get it from? What sourced the time? Is it, when we look at the forensic extraction, time can be controlled by a couple things. One, the network time, NTOP, the network time protocol, or GPS. So what's controlling it? And how was the time recorded? Was it the event start, duration, end? Was it something they looked back at? I absolutely, you're probably getting me too excited about it. I absolutely, every time I work a case and they're like, well, we got the time from the forensic extraction, I just like, please God, help us, because it's never right. And anytime, whenever it's, you think to this case, I think you would even find yourself, there's one of my eyes, there's too many inconsistencies in time as it relates to Celebrite. So then inconsistencies bear out one of the Daubert standards, I think, or Fry, or whatever you guys use on the East Coast, of reliability. If something's inconsistent, is it reliable? Right? And I would argue it's not.
Yeah.
So yeah, Mike, I think I totally agree with you. I think if you could look past time, the forensic extractions are great for content, photos especially. I've worked so many cases where kidnappers have photographed their victims or photographed evidence that they stole, that kind of stuff. So even text content, the names of people that are on their phone tree, because sometimes that's it'll say killer 2, and it's like, perfect. That's exactly what we wanted it to say, that kind of stuff.
How about the apps? I know when we were doing Aaron Hernandez, there was an issue about whether the app's time was correct versus, because all the apps seem to have different times versus the time that was done from the extractions. How does that play in, and was that done here?
Yeah, I think it's interesting. I think one of my fellow my peers, the guy I used to work with, testified in that case. So I hopefully I don't say something that's different than what he said.
Well, I had the two. We had the 2 not guilties on the double murder, so we didn't have the first case. We didn't have the first case where he was convicted. We had the not guilty case, which was after the first case was convicted.
Okay. All right. I don't want to contradict prior testimony from a colleague. I think what I would say then is, what was the app collecting? Oftentimes the user gives permission for the app to collect location information, and then what is the derivative of the evidence collected from the app? Did they use it for source location information? Then you should accept that the app time is GPS time, right? So it really would depend on what you're collecting from the app. If it's photos, you got to be really careful, because is the metadata from the photo is what's controlling time, or is it when the photo was sent, when it was taken? So I would think we would probably have a larger discussion on what the app's doing for you. But I tend to find apps are going to mirror device time. But we could talk about instances where that may not be true if the phone is no longer connected to a cellular network, no longer connected to Wi-Fi. There's some nuances. I wouldn't say there's always the one answer is the right answer. Would. Maybe I'm hedging my bets here, but just saying.
No, and then gets on. People have the app open. There's no Wi-Fi. They can't. The app doesn't record, and then they come to a place that the Wi-Fi or something is, and it does record, and then that gets all confused. That's
I agree with you.
Right? Yeah. That's the concept. No, that's really, really interesting. So when
Linda, I'm sorry, let me interrupt, Linda, give a little update on where we are and reset here. Michael Easter is with us. He's the witness that did not get to testify on behalf of the defense as to police procedures in this case. We are now in Justice Watch just past 3 hours, and we have not confirmed this, but we understand that the defense request to fix the verdict slip has been denied. Shocking. We're trying to confirm that.
Shocking.
Wouldn't surprise me, but that's what we're hearing. Anyway, I'm sorry, Linda, go ahead.
No, I just had, when you gave your final conclusions and opinions, how many opinions did you give at the very end with regard to what we call the Bowden defense? Because that's how Alan Jackson wanted to use you, that you can't trust the messenger here because, how they got to giving the message was really, it's a legal term, screwed up. And therefore it's an improper and incomplete investigation, and you need the specifics from you to say that. So what were your final specific 3 opinions, if you're allowed to get them, if you think you're allowed to get them?
Yeah, I sort of want to be careful, and I think you realize why. I think generally speaking, my report laid out opinions based on those 3 things that I already discussed, which is, what did they do? What was the best practice? And is it what they did inconsistent with the best practice and inconsistent with their own policy guide? And then I offered a conclusion of what I think ultimately those 3 I's, the incompleteness, inconsistency, and inaccuracies, how that led to their final conclusion, and whether you want to call it improper or not. Ultimately, those steps, I believe, created a final outcome that makes it hard to trust that the process was accurate, consistent, and yielded the correct suspect.
Mm-hmm. Oh, I'm blown away by this, and I'm blown away by the fact that jury could not hear this, Michael Bryant. I mean, it's ridiculous.
It's wrong. It's just wrong, but it's not the first thing we've said that about in this trial. That's for sure. Let me ask you, Michael, are you going to be following this? So I know you're on vacation, but do you have some curiosity about what's happening?
Yeah, 100%. It's interesting. When I retired, my focus was on.
You retired at what, 35? What do you mean you retired?
I'm actually in my 50s, but yes, I retired with the focus of starting my own company to provide, cell site and other location investigative assistance and trial and expert. What I found, and I never really thought about this sort of concept of providing investigative review.
Well, there you go. That's about it. Like, we got the main information. If you want to know just about him in general and the last bits that they talk about, please go and watch their channel. So let me pop that link in the description for you if you want to go get more. So yeah, I completely agreed with most of what he said. I think he's being very kind. There's the link in chat. I think he's being very kind, saying, you know, it just comes down to incompetence. I do not believe that that's incompetent. I believe that it is weaponized incompetence. They just decided, if we're incompetent, nobody can prove it otherwise, so we're just going to do that. So I got Channel 10. Hi, Arcane. Thanks for joining us. And I do have it in the background. I can switch over to that now. Let me put that tab back in. Hang on. Let me put this tab back in. And we'll switch over to it. Just wanted you to have a listen to his name, Michael Easter. Just have, if you want to learn more about him, there was at least another 20 minutes where he talks about himself and who he is and what he does. But anyway, the main things that I found interesting there was his the three things that he surmised about, or the three points that he made in his thing was just basically that they were, he didn't use the word incompetence, but the flow of the 3 points, I think, is what makes the most sense. So his first point was it was an incomplete investigation, and being incomplete, it led to inconsistencies, and then because there were inconsistencies in an incomplete investigation, it led to inaccuracies. It's being very kind, because we came up with at least 15 I words to describe the same things, but and more. But I agreed with him on that. I agreed with him on the Celebrite extraction and those timestamps being not reliable. If you wanted to get closer to actual real time, then you would be pulling your phone provider's records, and none of that was done. And so all their time shuffling is just guessing. It's just guesswork. But they spent an awful lot of amount of trial 2.0 and 1.0 arguing about this 2:27 a.m. search, which is just fucking dumb, because Celebrite's notoriously unreliable for that shit. Anyway, so the fact that they packed Jen McCabe's cell phone records around that 2:27 a.m. search, for those who missed it, I did a whole video on how much they packed. They stuffed her phone records all into this 1 minute, this 2:27 1 minute time. They stuffed it full. So she was making a search every second, or I might have averaged, I think it was like 1.8 seconds. She was making a search every 1.8 seconds for this whole minute. So that kind of gives you the idea that they had to stuff that whole minute, but that minute, the exact minute, might not have been when she was actually doing that stuff. If we'd had the Google lady come in and verify what the Google cloud was recording for those searches, would have been closer to the mark as to what time those searches took place. And then you would have been able to say, well, there you go. This whole minute got stuffed with searches that didn't get registered at Google's end, so they obviously didn't occur. They were stuffed by somebody else at the data end. That's what I reckon you could have, with someone like him as an expert looking at the records, surmise but they would have need to have called in their Google records person to be able to verify that that was a summation that he could come to. He wouldn't have come to it unless he had the proof in front of him anyway, just looking at the way he dealt with that interview specifically. So interesting. So I also found, what else did I look at yesterday? And I was like, oh my God, we got to do that one too. While we're waiting, let me just look through my history, because I know that there was a dozen things that I had teed up. I do believe, here we go. I do believe that Turtle Boy streamed some of his trial, and Paul, whoops, we need to keep the fan on the screen. Paul O'Keefe testified in his trial. I thought I might try and find that and dig around for Paul O'Keefe testifying. For a bit of a time waster. God, I'll be spewing if we don't have a verdict today. I feel like we do. I feel like we're going to. Who's on the jury? Seen outside of court. Restraining order, fake victim. So it must have been the next one. Yeah, because that one's only 20 minutes. So let's have a look at this one. Let's see what I find. Alan Jackson, reasonable doubt, big board. Spanky's closing, don't know, read questions and outro. Nope, not that one. All right. That's only 10 minutes. So this is the next one. It's just Jason told me about this yesterday, so I actually hadn't got to the point where I thought it was on any specific day. Spanky. This is all right, so I think it's a members stream because I'm not finding it. Dang. Yep, because he hasn't done anything else that is a non-member, so there you go. All right. You did watch Paul's testimony, and it must have really pissed him off that it resulted in Hayden's charge being dismissed altogether. They Yeah, and I agree with that too, Joanna. Like, if they want to be upset about who was drinking, about people drink driving, well, they all fucking did, right? Everyone who parked a car at 34 Fairview drove there from the bars. Everyone, not just Karen. So if they want to be petty about it, maybe they should be looking at that. Let's get petty. I don't know that they can, Joanna. I'm hoping that they can, because I feel like Bev's making, like, when she first shoved OUI into charge 2, I felt like, yes, they were going to have a hard time getting any kind of appeal, because it kind of looks like, you know, the judge's discretion. But at the point where she's now refusing to answer the jury's questions and making up fucking stories and still trying to direct them down this funnel path, I think we're actually getting closer to now this is actually something they could appeal. The way she did this was going to cancel all their appeal paths, and I think that's why she did it. Oh yeah, here's a bit of freaking awesome news. Check this out. Alan Jackson is the producer of a number of movies. So Ray Donovan, Homicide, and Spectre, the Phil Spectre. I'm pretty sure he was the district attorney who tried the Phil Spectre case. Actually, I think he might have been. Yes, I think these three are based on his experience as the prosecutor. So interesting, right? I didn't know he was a movie producer. So yeah, exactly, Joanna. Nobody got pulled over for drink driving. So if you're going to go petty on the drink driving, then they all were doing it that night. So think of how the jury is going to feel when they find out everyone was drinking and drunk driving, including the children. Yes. Yep, they're all going to feel pretty stupid afterwards. So, but anyway. Interesting, right? Anyway, keep an eye on that OnlyFan. I thought that was interesting that Alan Jackson is a movie producer. A juror from Reed's first trial, who will remain anonymous, says to me in response to this tweet, yep, that's a great question. Hopefully they get it right this time. Christina Rex is saying this. So the question was, if we find not guilty on 2 charges but can't agree on 1 charge, is it a hung jury on all 3 charges or just 1 charge? And that was where judge went, yeah, we're not going to answer that. That's theoretical. No, it's not. It's a fucking matter of law. And it's your fucking job to answer matters of law. So yeah, Christina Rex is full of fucking shit. But anyway, I got not a lot from her for the last hour. The real juror to Christina Rex, tell Ronnie he's gutless. I thought that was funny. Oh, she didn't even call the jury in to answer that 4th question. She just sent a note back. And I think it's good. It's good, Bev. Don't answer them. Don't answer their questions, and they will just go, all right, well, not guilty across the board, because we won't take the risk that she is going to, that they're going to misapply our decision. They seem smart. They already pulled out the smart part of the Discord. I haven't even got Discord open, Michelle, but give me 1 sec. And I will open it. Give me Give me 5 seconds, because you know how fucking Discord is. It's got to do the whole fucking check, double check shit. Aussie link to TB trial in Discord. Thank you, Dale. They have to come back in the next hour, or they won't come back till tomorrow. She's cutting them off at 4. Me too, Bella. Complete controlling, micro fucking management bullshit control freak. All right. Shell Carney trial. Oh, Michelle, and I don't want to put that one on the screen because I don't like them. Yeah, I don't want that specific channel because they will strike me. We need a different channel. That's why yesterday when Jason said Total Boy actually put it on his channel, that's why I was there looking for that, because I know he won't strike me. So it's all I'm good, I can see it, but I don't want that specific channel. Give me someone who's not an a-hole. I just realized something else is that the judge doesn't want to answer the question because she's got to say it in open court that yes, of course, it's going to be a retrial on manslaughter, the main charge. But I don't think that's how it works. Like, looking at the case law for the Commonwealth specifically, yesterday we discovered that nope, you can have a partial verdict on lessers without the overarching charge being retried. You can have that. So we were like checking and double checking yesterday on that. That's not how the judge will rule, but she could because the case law supports it. But we know that's not how she will rule. They must be harassing Haley. Let me see if Haley's free. Are you in the office? Okay. Oh my God. This is a cool picture. Look. It's Nan and Rita. Bloody awesome to see Rita back on the ground. It is behind a paywall. Thank you, Kevy. I thought it would be. That's all right. We'll get to it eventually. We'll get there. Isn't that cool? Rita's back on the ground again. She said she needed some downtime. She needed to take a break from the whole thing. She needs some downtime. She needed to be able to put some time towards, her town and her life and her family and all that sort of stuff. So I get that. I sent her a couple of messages saying, anytime you feel like coming back, just let me know. She didn't feel like coming back. So I'm glad to see her on the ground for this verdict. Bloody brilliant. Thank you, Rita. Aiden says, earlier in the hallway, I saw Karen Reed and I said, those are good questions, to which she replied, yeah, you think? I quoted the wrong person in a previous tweet and like to correct myself when I make a mistake. Karen's not feeling good about those questions. Come on, Karen, these are freaking way better questions than the last jury was considering. Yeah, it's behind a paywall, according to Kev. So I did have a membership but I don't now. Okay, better also brace yourself for the doomsday scenario that only would happen in this trial. A hung jury on a middleman or OUI, and the possibility of confusion that results in a possible retrial of a manslaughter. Point that may very well be acquitted as the jury wrestle with a misdemeanor. This is coming from Betero. Let me see what else he has typed. Call it a hunch, but I expect a verdict within 90 minutes. That was 2 hours ago. There goes your hunch. 5:30, good chance. 5:30 p.m., good chance we are discussing a verdict tonight. Notes that seek clarification. This is all Betero in case I didn't say that, guys. Notes that seek clarification on the law often portend we are close to an end. As far as the OUI instruction on timing, that was a huge win for the defense in terms of reasonable doubt. I agree, Battery. The clips are what they are, and the jury will have to determine if Karen's admitted drinking does anything. Either way, I anticipate a verdict today if the jury gets instructed soon and understands what the judge tells them about the slip for count 2. All in all, the defense should feel very good right about now. Yes, I agree with Betero on that. As all of the charges related to the death of Officer John O'Keefe appear to be on the verge of acquittal, bless the prosecution for fighting to the death and demanding the time of the alleged OUI to be interpreted in the light most favourable to the Commonwealth, even though they specifically declined to plead the time in the indictment and for opposing common language, if any, in terms of what weight to apply to any particular evidence, which suggestion is absolutely the clear instruction. It is. I agree with that too. Better is on the ball. He's on the ball. Or is it I'm on the ball? And I'm just agreeing with him. Someone's on the ball here. Thank you, Kevy. Let's have a look. Sound quality is not great, but it's on the Zoom feed. Yes, see, this person won't strike me, I don't think. Let's get that one happening. Alright. So I need to drag the Only fan out into the background so I can see when it stops spinning or shit starts happening. And then switch tabs to this one. Now, before I hit the play button, I'm just going to read the rest of Bettero's posts. He says, also brace yourself for the doomsday scenario. Oh, we read that one. To the surprise of absolutely nobody, the jury appears confused on count 2 and the lesser included. It does appear the jury is entirely focused on the OUI based on all 3 questions, which seems to be a very bad sign for the prosecution. Thank you for supporting what I just finished saying, Betero. Mind you, he posted this all hours before I said it. It does appear the jury, yep, got that. However, the inclusion of the OUI does seem to be making at least one juror consider that off-ramp rather than a full-blown acquittal. And all in all, it didn't sound great for a conviction on any of the homicide charges. Interesting. So I don't think we're going to get a conviction on the homicide. Paul O'Keefe starts at 3 hours and 33 minutes. Thank you. Kemi, let's go to that. 3 hours 33. All right. Let's listen to what this slime ball says.
Did you know who Lindsay was when you saw her going to court? Yeah. How were you able to recognize her? In other words, I'm trying to get at what's your basis for knowing what Lindsay was? My cousin showed me a picture of Lindsay. No, tell me why. Your cousin showed you a picture of Lindsay. And what was it, a recent picture? You know where that picture came from?
This is Cosgrove asking questions. Bradle's like, sigh.
And I think you were established because you're standing Mr. Crane the whole time, and you never moved. How close to him were you? I was talking about so 10 feet away, 20 feet away? 25, 30 feet. 25, 30 feet. Yeah. By the way, how far? I don't know how big you are of destination distances. You're not. You watch any football? You ever watch the football games? No. You have a picture in your mind about how long the football field is. Could you say the distance between where Mr. Crane was standing, front steps to the Superior Court, was greater, lesser, or about the same distance football? And couple more questions. Write this academic such. These are all words that she wrote. So you seem to start number one, the final page was resident of Commonwealth of Massachusetts. Those your own words.
Trying to turn the volume boost on for you.
You may step down, thank you.
Paul Keith, get your own. Paul Keith. Paul Keith.
Do you swear in the matter now in hearing to tell the truth, the whole truth, and nothing but the truth to help you God? Thank you.
May I inquire, Your Honor? Good afternoon, sir. State your name and spell your last name, please.
Okay. Okay.
Where do you live, sir? Just in general. What do you do for a living?
I'm in sales.
And where do you work?
Singleton Streets.
How long have you been so employed?
13 years.
And do you have a family in the area? Just generally. And who's your family, just in general?
Father, nephew, wife, children.
And you have a family connection to the prosecution of Karen Reed across the street, correct? And it's, your brother had passed away, and he's the case involves his death across the street, correct? And you attend the court hearings over there? All right. And you know the gentleman with me here today, Aiden Carn, correct?
Which one I do?
Yep. And he's someone who you don't like.
No.
Right? No, I'm not correct, or yes, I am?
No.
Okay, thank you. And you've had text message or Facebook message exchanges with Mr. Carney, correct?
Once or twice.
And just to summarize it, and you can look at it if you want, but just in the interest of moving along, you sent him a Facebook message saying, "I'm taking you down. I hope you know that you're done. You're going to jail again, actually prison this time. I hope your kids are prepared. So I look forward to that." Is that right?
Busted.
That's a really small part conversation.
Sure. Sure. I'm just trying to get to the nugget of it. If you want to look at it, I'm happy to show you. But that's the nugget of your sentiment towards Mr. Carn, right?
Yes, I mean, that was sent out of frustration from all the harassment the defendant has given to me and my family, friends, so slew of reasons.
Sure. And that's an accurate summary of your emotions and your feelings towards Mr. Carn, right?
I would say at that moment, there was words out of frustration.
Sure. And in terms of your case across the street that involves your brother, it must be difficult or annoying or frustrating or produces anger in you that Mr. Carney is a frequent visitor, a frequent commentator, and a frequent critic, right?
Among other things, yes.
And so it would be nice to get him out of there, right?
I don't care for him to be there, huh?
Sure. And so how did you come to be acquainted with Lindsay Gattani?
Goodbye. We both
Do tell.
experiencing the same harassment from the defendant as well as followers.
So you feel like there's an affinity with you and Ms. Gattani in terms of being criticized or exposed by Mr. Carney?
Harassed, I would say.
So back to my question, when did you meet Ms. Gattani?
I meet her. In the days that the defendant was removed from work across the street. Back in February 2024.
Okay, if I suggest 2/26, that hearing that was on 2/26/24,
That sounds accurate.
and you'll recall that was the hearing where there was a number of things on the agenda, but court kind of got done pretty quickly that day, right?
It's an afternoon session. I don't really recall what was said. I think many court dates the last couple of years. So says specifically.
Okay. In terms of you meeting or speaking with Ms. Gattani, when was the first time you spoke with her?
That day I introduced myself.
What was that?
I said, nice to meet you. I think I applaud her strength. That was it.
Was she there? Was she invited there by you?
By me personally, no.
To your knowledge, who was she invited there by?
Someone had asked me if it was okay if she went to court that day. I said, sure. I don't remember who actually asked me that question.
Was it Kate Peter? Do you know Kate Peter?
I know who she is. I don't know if I said I know her.
Have you ever spoken with her?
I've spoken to her once.
Yes.
And when was that?
Once in a phone conversation, and then I believe once for defendant's arraignment.
What was the time frame of you speaking with her? When was that?
When did I talk to her?
Yeah.
We don't know, to be honest.
Was it prior to 2/26?
Possibly.
Kate Peter facilitated this entire visit of Lindsay Gattani to court on 2/26, didn't she?
Yes.
By someone that was okay with me, she came. I said, okay. Public court knows. At that time, the going to court, we were greeted by, we had to go through a gauntlet of people joining and screaming at us, which was organized by the defendant and incited by the defendant.
So try to just focus on my question, okay? It's a question and answer process.
Answer the question, buddy.
So, when did you speak with Ms. Gattani that day? Where were you?
We were in the back parking lot of the Registry of Deeds, where everyone meets and walk over together.
How did you come to meet her in the back parking lot of the Registry of Deeds? What was the plan? What was the organizational situation about meeting up there?
In the back.
When we were to court, we knew that we parked back there, and that's when we met and walked over to the group.
So is your testimony that was some sort of just a spontaneous thing that you guys ran into each other back there, or was there some sort of a plan?
I pulled into the parking lot with a group of people. I got out, 3 people, she was one of the people that was gonna leave.
Did you know that she was gonna be there?
I'm assuming she would be, because I was asked if it was okay with me. So I was under the assumption that it was a likelihood she would be there.
So you were asked by someone who you're not sure it was, if Lindsay Gattani could be at court, and then she materializes at court.
And you walked her in.
Where did you park in the Registry of Deeds parking lot? Close to the building, far away from the building, whereabouts? Away from the building? Now, would it be correct to say that you did not invite Lindsay Gattani that day?
Personally,
Did you or your family, to your knowledge, express any invitation to her that involved your family wanting to support her and recognize her and be with her at your brother's case?
I think it was asked me if it was okay if she went.
Was there anything about supporting her or helping her or anything? It's fair to say you were more focused about your brother's case, not Lindsay Gattani's case?
Tricky, tricky.
Did you walk in with Mrs. Gattani?
I believe the group that met in the parking lot all walked in together, yes.
Did you know that she had a restraining order against Mr. Carney at the time?
I believe I did, yes.
Were you trying to use Ms. Gattani to evict Mr. Carney from the courthouse?
Was I personally? No.
Was your family doing that? Who was doing that?
Objection. Sorry. I'm 16, you don't have to guess this.
So just coincidentally, on the first time you met Ms. Gattani, she had a restraining order against Mr. Carney, right? And she had it in her hand when she went in the courthouse, didn't she?
It's over the timing.
Did you see her with a piece of paper in her hand when she walked in?
I don't know.
Did you see when she walked into the courthouse?
Yeah, she's behind me. See her walking, so.
Did you see her when she walked into the courtroom that afternoon?
That behind me as well.
Did you see her when she came in and sat behind you? Did you speak to her at all in the courtroom? Did you have an awareness that Mr. Carney was in the courtroom on the other side of the aisle?
Yes.
Did you speak with him or see him or have any interactions with him?
Oh, at that point. Later in the day.
Did anyone ask you to invite Ms. Gattani to any hearings before Mr. Carney had gotten out of jail, such as January 5th or January 18th?
That was the whole time.
Just when Mr. Carney was out of jail and when Ms. Gattani had a restraining order, right?
Correct.
That's right,
Did
Joanna.
you speak with Jennifer McCabe that day at all?
Don't think so.
One moment, please, Your Honor. Thank you very much for nothing further. Thank you, Your Honor.
There you go.
If I could perhaps answer correctly to Mr. Cradle's question, I had interaction with this train. Is it the nature of nothing, but they were on that day? Correct. Can you describe that for us, please? Leaving court, I was ambushed by the defendant, harassed.
Ambush?
With his camera in my face, telling me several times that I was disgraced to my brother. Now, did you leave? Do you know if you left the court at the same time as Ms. Gattani, or did you leave before or after? Both after. About how long after you know? I don't know. I'm going to direct your attention to the screen up there. And as is typically my launch, I've forgotten the number, but I think what we launched is February 27th, 2024. Ms. Crawford, would you play that, please? Well, you really shame it all.
Crawford.
Or something like that. Yeah, funny. You think domestic violence is funny? Do you? Aren't you? Do you think domestic
Gets Crawford. Did you hear that? Ms. Crawford is actually playing the audio visuals in court for Carney's trial, but for those who don't know, Crawford is she's the one who doctored all the videos in Karen's trial. That's who Crawford is. Interesting. Interesting.
violence is funny? Yes or no? You are a disgrace, dear brother. A disgrace. You are a disgrace. I'll see what I'm not wanting. Showed up for the first time tonight with you guys. Showed up with you guys. Disgusting. Disgusting, Paul. Disgusting. Disgusting.
Yep, he's allowed to say that shit.
Fair and accurate representation of the action participated in that visit. You later see it played on one of Mr. Kerman's YouTube presentations. Yes. Did you observe at any time during your interaction with Mr. Kearney on meditation that he appeared to be distraught? You were upset. And what was the sense of him being upset? Did you get that one?
What was the sense? I think it's because he was a little world. Told us about I had something to do with this, which is probably why I'm here today.
And did you observe him to be trembling, shaken?
Was he mostly angry?
Thank you, sir. Not further. Anything I need to write?
So that's a tape recording, Mr. Pete, of your interaction with Mr. Carney after court that day?
Yes.
And you said to him, don't get too comfortable?
Yes.
And your mom said, where's Lindsay? So, in other words, you guys knew exactly what was going on that day, and you were taunting Mr. Carney about the presence of Lindsay Gattani, weren't you?
Say taunting. None of that was said. I didn't in my face.
Nothing.
Nothing further, Your Honor. Thank you.
Anyone else?
Sorry. Jack Carney.
Jack
John Carney.
John
Jack.
Carney.
Sorry.
John Carney?
You got a book from Brad from yesterday? Raise your hand. Do you swear in the matter now in hearing to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, I do.
Thank you.
May I inquire? Good afternoon, sir. Good afternoon, sir. Please state your name and spell your last name for the record, please.
John Carney, C-A-R-N-E-Y.
Where do you live, sir? Just in Canton? How long have you lived in Canton?
3 years.
What do you do for a living?
I'm retired.
Just tell us about your family in general.
I have 2 sisters, a brother. My mother lives in Norway.
What did you do for a living before you retired?
I retired from the military when I came home from Iraq in 2006.
What did you do in Iraq?
I drove tractor trailers, hauling fuel.
Is this his dad?
Have you taken an interest in the Karen Reed prosecution in the Superior Court across the street and the Aiden Carney cases as well?
Yes, I have.
And when did that interest start?
Karen Reed, first day.
Have you been following that matter?
Yes.
Do you attend court hearings and events in Dedham relative to that? How long have you been doing that?
What, following it?
Yeah.
Oh, since the
Or
beginning.
attending events and such?
Yeah.
Okay.
Whenever I can.
Sure. What, let's strike that. Were you present on 2/26/24 across the street at the Superior Court for a Karen Reed hearing?
Yes.
And that day, were you outside the courthouse or were you inside in the hearing?
I was outside.
And what were you doing outside? What was your plan for the afternoon?
Well, I was gonna try and get in, I couldn't get in, so, I just stayed at the bottom of the steps there.
Oh, sorry about that. I think that was me. Sorry.
Beep beep. Drive safe, Michelle.
At some point, did you see Mr. Carney come out of the courthouse?
Right.
Yes.
Thank you, Joanna.
Where was he when you first saw him?
He was coming out the front door,
Where were you when you saw him?
the bottom of the steps.
What did you see him do when he first came out?
When he first came out, there was a bunch of people there. And, he said he had to leave the court because of some issue with a restraining order. And,
Next
he
question.
said, let's go across the street. So he went
Hold
across,
on, let me ask you another question. Did he do anything with his phone around that time?
not that I saw him.
Okay. What did he, where did he go after he came out and said that?
He said, let's go across the street to the, registry of deeds.
Did he speak with anybody in the hall, in the crosswalk?
Yes.
What did you see happen there?
I heard him talk to a police officer that was in the middle of the road, that he was directing traffic.
If you please.
He said something
For the
about,
record,
Not sure what.
I'm
What
checking.
piece system. Yes, exactly.
He answered me so far, I'll ask him the next question.
I can go back and listen.
Thank you, Jordan.
It's unclear who's doing that whispering, but
After you saw him go into the crosswalk, what happened?
he talked to the police officer.
Did you see what was said?
I heard word, yes.
What did you hear?
He told him about that he had a restraining order, some lady had it against him, and he had to be so much distance away from him, and the cop told him to go over there to the, registry of deeds.
Okay, you just gestured when you said that. Did the officer gesture?
Yes,
What happened?
we just went over to the registry of deeds.
Did Mr. Carney go to where you saw the officer gesture?
Yes,
What happened after Mr. Carney got up there?
he started talking to us, and, we were on the flat top there, the very top there, and he was talking to us, and then behind us, the people started coming out of Superior Court.
Next question.
What time approximately did people start coming out of Superior Court?
I can say.
How long after 2 o'clock would you say people started coming out of Superior Court?
I don't know.
Was it a long time period or a short
No,
time?
it was short. It was short.
What did you see in terms of people streaming out? How many people?
There was a line of people.
A lot of people or a little amount of
It
people?
was a lot.
Did they cover the front of the courthouse or did they only concentrate in one area of the courthouse? In the front?
Pretty much the front.
Do you know someone named Lindsay Gattani?
I have never met the woman.
Do you know who she is if you see her?
Yes,
Did you know on 226?
yes,
Did you see her that day?
yes.
Where did you see her go?
In front of the courthouse.
Where did she go?
In front, if you stand in front of the courthouse, you went to the left towards, Devon Center.
So was she going towards the Registry of Deeds building or away from the Registry of Deeds building?
Away, heading to Devon Center.
Around the time that you saw her going towards Dedham Center, did you have an awareness of where Mr. Carney was?
Yes,
Where was he?
he was behind me.
How far away?
He was at the top of the stairs, closest to the building, and, I was on the side, I went down the sidewalk to film. 20 feet.
Relative to that might have been was there.
No,
Did you hear him say liar, liar?
no,
Did he say or do anything that made you think that he may have been aware of Miss Gattani in the vicinity?
no, I didn't have anything.
Thank you, sir. Nothing further.
Cross-examination. No, wait a second.
Oh,
No, he was just getting water.
Thank you.
You said you saw, pick up, where you left off, you said you saw Winston County that day,
Yes,
and, you didn't have any trouble picking her out or recognizing her.
no,
How is it you know what she looks like?
I've seen her on Facebook, pictures,
Okay.
I've seen her in public before.
Oh. On whose Facebook page did you see her in front?
I could be.
No idea. No. And you've seen her in public before where?
I want to say I saw her at the courthouse before.
All right. Has she been a regular attendee to the Karen Lee hearings, would you say?
I don't think so, no.
You seen her on the courthouse on other occasions then?
I think I might have seen it twice.
Oh, but you remembered what she looked like?
Gotcha.
And anybody standing, you were across the street from her, saw her, right? And was she proceeding down the ramp?
They all were, yes.
Yes, but you didn't have any trouble picking her.
No, there were other people there that I
Anybody
didn't.
looking across the street wouldn't have any trouble picking her. So how she?
Right.
So you said that at some point you left Mr.
Here we go.
Carney and you went down to the video.
Hang on. Jury is coming in. At least we have better audio than the other courtroom in this one.
All right, jurors, I know you want to go home, so it's been a long day for everybody. I have to give you those same cautions. Please do
Damn
not
it.
discuss this case with anyone. Do not do any independent research or investigation into the case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. Be careful with your social media use. We know you've all been working really hard and we appreciate it. So please just clear your heads. Don't think about this case at all as best you can. And we'll see you tomorrow morning when everybody's fresh to start again. Thank you.
All rise for the court, please. You're following.
That's it, guys. Thought we were going to get a verdict today. We all did. I mean, they're so close. They must have a holdout. Let's see if she's going to deal with anything else for the end of day.
Jury's exit the courtroom.
Okay, Tori. All right, we'll see everybody tomorrow.
Thank you. Court is adjourned.
That's it. I think that's what it is, Joanna. I think there might be... Well, she admitted it. So this is what happened in the Laurie Vallow trial. The thing that... I guess I should be specific because there's been 3 for her. So she said... one of the jurors had said at the end of the conspiracy to murder Charles trial that it was her own words. Like, he was on the fence and didn't want to convict until he realized that it was her own words. And I think that that's what Brennan was aiming for. And I think it was a mistake for the defense not to pay attention to her own words and like put them back into context. I would have mentioned in closing, you know, everyone was drink driving. It wasn't just Karen. Yeah, but I think that that's where Brennan was coming from with the whole deal, basically. So yeah, interesting all round, right? Interesting all round. Thought we'd have a verdict by today's end. We're all suitably disappointed, I would say. I guess, you know, the jury's probably as disappointed as anybody because they're the poor buggers who've got to sit back there and argue about it. So, doo-doo happens. A little annoyed, but let's hope they come to the right decision, hey? That's about all I can say about it. All we can do is hope. A little bit disappointed here. I really hope we don't get a hung jury. Yeah, well, fingers crossed for that, right? Fingers crossed on that. Very disappointed. There you go. We can watch the rest of Carney's trial. So we got an hour of that left to hear the judge's ruling. God, I feel like maybe that's where we're going. Like, if we got a decision from them today, I feel like the judge was forcing them into a decision today just by not answering their questions. It was like, well, if you won't answer that, then we're not convicting her. That's how I thought we were going. But no, that's not where we're going at all. I feel like maybe we're going to be hung again. And the Commonwealth would be very pleased with that because obviously they have an endless supply of money. And that sucks. Anyway, let's continue with Aiden's hearing. I guess we can drag that tab back in and be all on the same screen so I don't have to watch the OnlyFans anymore. Whoops. Did I just frigging... Nope. I thought I cancelled it. Alright, let's continue with this.
Yes. Why would you do? I'm following the trial. Just like everybody else.
Is there something particularly memorable about a group of people exiting the courthouse?
No, I was just proud of how it was.
So you figured you'd keep that as, what, souvenirs?
Yes.
All right.
Not really souvenir.
Well, did you do anything on the video afterwards?
Yes, I did.
What'd you do?
I sent it to Mr. Connie.
All right. And why did you do that?
Because he was looking, I guess because he was looking for
Well, now tell me his reason. Just tell me why you did it.
why I did it.
Yeah.
Because I want to help somebody who's
Well, that you wanted to help Mr. Bernie and you thought you sending him the video without him someone?
yes.
Did you request that you send him a video?
No,
Yeah, Gina, that was
Was
AJ.
there a general request by Mr. Kearney?
not what I know.
So you just did this on your own?
Right. Yep.
Oh. So you sent Mr. Kearney the video. Are you a regular viewer of his shows?
I look at pretty much everything.
Okay.
The Herald, everything.
You think all those out, the Heralds, Howie Carr,
Maui God, I look at them all.
all the great.
Yes.
Okay. So, do you subscribe to Mr. Kearney's pay channel?
No.
Have you donated to his defense fund?
No.
You donated to Karen Reed's defense fund?
Yes.
How much money do you send Karen Reed?
Less than 1,000.
Who cares?
Close to 500 or close to 1,000?
Close to 1,000.
Okay. So you're pretty committed to this process.
So
Mr. Kearney is a vigorous advocate for Karen Reed, is he not?
yes.
In fact, I mentioned to say,
Okay,
you watch
Kev,
him regularly.
help today.
Not right. Is it?
No?
No, I watch it off and on.
Watch him off and on.
I'm in bed at 9 o'clock.
Have you ever heard him say anything negative? No.
No.
You ever heard him say anything good about the prosecution?
No.
And can you endorse those things?
Yes.
So you're here today to help.
Yes.
Serious? That's the line of questioning.
Now, as I understand your testimony, when you see Mr. Kearney coming out of his Norfolk Superior Court, Mr. Kearney says, I think the words you used were, let's go across the street to the registry of deeds. Is that right?
Yes.
All right. And then after that, as you're crossing the street, presumably to get to the registry of deeds, Mr. Kearney stops and speaks to a police officer.
Yes.
And as a result of that conversation, did you say the officer said, why don't you go over there to the registry of deeds?
They go up top there. Yes.
Go up top there to the registry of deeds. You distinctly heard the officer say the words registry of deeds.
I heard registry of deeds.
Like you don't know whether you heard it from Mr. Kearney or you heard it from
I believe it's the officer.
the officer. Okay. So the officer, so Mr. Kearney, is this fair? Mr. Kearney had already announced that he was going across the street to the registry of deeds, and he stops and talks to the officer. The officer, in fact, tells us to go where he was already going.
Objection. Oh. Yes.
Me, what is out with these
Okay.
questions? Like, let's just start from the question he asked us a minute ago. He said, has Mr. Kearney ever said anything positive about the prosecution in the Karen Reed's case? It's like, why is that even a fucking question? Like, it's no wonder this judge went, yeah, nah, we're dropping the charges. Because just in his line of questioning, he's more or less admitting that this is because Aidan Kearney has spoken out against that prosecution. It seems like self-defeating at this stage.
Mr. Kearney, you executed an affidavit of mistakes, did you not?
Yes, sir.
Is this it, or photocopy of it?
That's it.
You signed it under the names and penalties of perjury.
Yes.
And is it fair to say that you explained the events in this affidavit consistent with your testimony here today? That is, that, well, let me read it to you and you tell me if it sounds like I'm reading it correctly.
Objection, Your Honor, it's not how.
If you could just ask a question, witness will answer it. As long as you're framing it as a question, Mr. Cosgrove, go right ahead.
All right. Do you recall writing in your affidavit? Mr. Kearney said there were some issues with the restraining order. He was going across the street of the registry of deeds to comply with the restraining order. And I, along with others in the crowd, followed Mr. Kearney across the street to the registry of deeds.
Yes.
And then the next thing, you recall that the next thing you write was that while you were crossing the street, you saw Mr. Kearney speak to a police officer.
Right.
And then after you finished this some more there, but after you finished with that account, you then say, we continue to cross the street to the registry.
Right.
Right, it's exactly something very important. It's all around.
Right.
So the first sentence I noticed says, I am an agent, a resident of Commonwealth of Massachusetts. Are those your words?
Yes.
Anybody revise your words and make any suggestions?
No.
What?
The residency.
Yeah, so resident. Yeah, you are a resident of Massachusetts. Sure. And did you, at some time before, after, or during your writing this affidavit, did you deliver it to Mr. Bradle's office? Did you mail it, speak with someone? How did you get it to him?
I talked to his paralegal.
Oh. And after you talked to her, did you make arrangements to get it to Mr. To her?
Yes.
What were the arrangements?
I believe, I had some email, so
You think you emailed it to him?
Yeah.
All right. And did you say you served in Iraq, sir?
I did.
Good. Thank you, sir. No further questions.
Nothing further.
You may step down, sir.
Also.
Wow. They got nothing. But this is what you get for building your whole case on
One moment, miss, 5 minutes, it's an officer.
rumors of the internet, right? It's pretty funny.
Paul Katie?
Paul Katie?
BT? I can hardly understand them. The audio is so bad.
Judge, before Mr. Braille, begins this establishment, I think we heard it on this.
Would you raise your right hand? Do you swear in the matter now I'm hearing to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Based on. So, testify on this. Those videos already.
Oh, it's the cop. I think this is the cop that he asked about when he left the courthouse to get away from Lindsay. This is the cop that he asked where he should go to be within his restrictions. I don't know which lady you're talking about, Casey, because they're all making faces. It's about the one right, all the way over here on the right. This one over here.
Well, I think for this to very much is introduce the videos. But the court determined is like really good on the videos. So what we did some offices different from what you could.
They must be having a sidebar.
Witness has been sworn.
Name inquiry, Your Honor. Good afternoon, sir. Please state your name and spell your last name. What do you do for a living, sir? I think we get it, but for the record. And how long have you been so employed?
Born 2005.
I'm sorry, how long have you been with the Dedham PD?
About 20 years.
And tell us a little bit about your educational background, training, etc.
So, I went through the academy, graduated through that. And after that, I went to school to do my master's degree in criminal justice.
Now, do you know who the gentleman with me here is today, Aiden Carney?
Yes.
And had you met with him relative to a case that happened back in late February of 2024?
Yes.
Do you recall when you met with him?
During one of my shifts when I was working station.
And Mr. Carney approached you with some video from the incident that he wanted you to look at.
Yes.
How many videos did you look at with respect to Mr. Carney?
When we first came in, I'm not sure. I think overall it was around 3, but when we first came in, I know you sent them.
How many videos ultimately did you look at relative to Mr. Carney?
At least 3.
And they involved an incident from 2/26/24 that transpired outside of the Dedham, the Norfolk Superior Court in Dedham.
Correct.
The building across the street, correct?
Correct.
And just in a nutshell, were those videos of people leaving the courthouse that day?
Yes.
Were you focused on some people leaving the courthouse that day?
Yes.
Just so you know, she fake victim actually posted a photo. I think it might have actually been Grant Ellis Smith who posted the photo on X where she was trying to claim Aiden had, let me see if I can find it. Aiden had scratched her car up that day. That's what she was claiming. And it was pretty weird because in the reflection in her car, the reflection of the paint in her car was actually a Christmas tree. Why can't I see it? It must have been last year, and they're not showing me last year. Which basically demonstrated that the ding, she was claiming that Aiden damaged her car out there in the registry of deeds, but the photograph that she's trying to use as evidence has a Christmas tree reflecting. I think it was on the back windscreen or the back window quarter panel or something. But anyway, I thought that was interesting because we already debunked her stupid photograph, but I'm sure that's what the cop's going to testify.
What were you asked to do in terms of looking at those videos that Mr. Carney supplied to you?
Excuse me, ask that goes.
By Mr. Carney. What did he want to invite your attention to on the videos?
He had come in originally to report a false police report. And so he showed me the videos in his defense about how he didn't do it.
So he was reporting what he was stating was false claims by Ms. Gattani, Ms. Lindsay Gattani.
Yes.
In terms of investigating that matter, did you look at the videotapes?
I did.
Were you able to ascertain whether or not Mr. Carney is on any of those videos saying anything towards Ms. Gattani or at Ms. Gattani?
I was on it.
Were the people that were making those videos to your investigation, to your ascertainment, near Mr. Carney such that it would have appeared on the videos?
Yes, when he told me he was, that's where he was standing, then yes.
And Mr. Carney had brought it to your attention that there was a restraining order issue in the case, right?
I believe so, yeah.
And so that if there was any evidence that he was trying to communicate with Ms. Gattani, that would have been a violation of the restraining order, right?
Yes.
And you were the investigating officer. You looked at all the body of video and you were able to find no information consistent with any restraining order violation, correct?
Correct.
Nothing further.
Cross-examination.
It was a pretty poor bloody show, wasn't it, Joanna?
In terms of the videos,
She faked every bit of evidence she tried to get him locked up with.
Do I understand that all of those videos to your recollection show completely visual report? Yes. And do I also understand that Mr. Kearney told you where he was standing? Yes. You didn't actually see Mr. Kearney in any of those videos? No. So the point of showing you the videos as Mr. Kearney's point of showing the videos, as you understand it, was to show you that he could not be heard in any of them shouting and raising his hand. Correct. And would it be your expectation, officer, that if somebody was trying to prove to you that he could not be heard shouting at someone, that he would deliver to you if he had a video of him shouting at that person? If we had done enough. But he told you he never shouted anything else. Correct. Did he tell you he always maintained the distance of 100 yards away? Don't think that was discussed. Didn't bring that up. That's my recollection. If there were a restraining order that said someone had to keep 100 yards distance from someone, and he was within 100 yards of that person, in your judgment, as a police officer, would that be probable cause to arrest that person? Yes.
Hey, Jim.
Did Mr. Kearney ever tell you, to your recollection, that
Couple of days old now, Jim.
He didn't say Lindsay the time. But did Mr. Carney have a problem that he didn't say Lindsay the time? No. Oh, very well. Thank you, my friend.
Just in terms of that, Dr. Katie, just briefly, did you also look at Ms. Gattani in the video?
He pointed her out, yes, I couldn't play with her.
And did you watch that person to see if they registered any reaction to being yelled at or screamed at by him?
I did.
Did you see any reaction on her part?
No.
Thank you.
Anything on the cross? No, thank you very much.
You may step down.
Thank you.
That's all we have to the defense restaurant.
We're gonna take a break. Is 15 minutes enough for both of you?
Yes.
And then a total of 30.
Yeah.
Thanks. Take a short break.
Thank you.
Board, all rise.
Call will be recessed until 3:40.
3:40, folks, 3:40.
Let's get it back. Here we go. It's awful sound, and I'm sorry. And Jim, this is Aidan Carney's dismissal a couple of days ago.
The government, stated in legal terms, Your Honor, the government has certainly not proven this case beyond a reasonable doubt. And you're the fact finder, and we don't need to reiterate the standard because you apply it every day as a judge. That day, Ms. Gattani came into that courtroom wielding that restraining order like a sword, not using it as a shield. She was there for one purpose and one purpose only, and we know that from the circumstances. We know that Mr. Carney had just gotten out of jail. We know that Ms. Gattani had the restraining order, and this was Mr. Carney's first appearance back in the case after getting sent to jail on her charges of assault and battery in this court. She came in there and she was ready with her restraining order for one purpose and one purpose only, not to be there for the Karen Reed hearing, but to evict Mr. Carney, to cause a to try to cause a restraining order violation. And I appreciate the Commonwealth saying it. Mr. Carney did the right thing and he left. It was about 19 seconds, if you look at the video, and I know you have 19 seconds between the time when Gattani went in the room and Mr. Carney went out of there. He didn't say the F word to her.
Before we do the closing arguments, let's see if we get Lindsay Gattani on the stand. That was Meredith. So I think actually Meredith's was good. We should listen to hers. Fuck, she was up for ages. He was after Meredith.
Where was he when he started to do that?
I want to say, maybe it was like around the base of the stairs. Maybe leading out into the sidewalk.
I'm sorry. Okay. When he came out, did he draw your attention or were you looking at other things besides Mr. Carney and saying?
No, I was looking.
And what did you see him do and where did you see him go?
Well, I saw him, there was a state trooper that was there on the.
Objection, my question is, what did I say for the question?
What did you see
Listen
him
to
do?
the question and just answer that question, please.
He began moving down the stairs and started to cross the street. He approached a dead police officer.
You were going to talk about a state trooper. Did a state trooper approach him as well?
Yeah.
What happened?
The state trooper was concerned about.
Objection.
Just what did you see happen?
So I saw the state trooper usher folks off the stairs and to continue moving.
And was Mr. Carney part of that group of people that were being ushered around?
Yeah.
Where did he go?
He then was walking into the street. He approached a Dedham police officer.
Was that Dedham police officer busy doing things, or was he just completely focused on Mr. Carney?
No, there was a lot of people around.
Next question.
Yeah, just
Did you
answer.
see Mr. Carney speak to him?
I did.
What was said?
I did.
Notice and outline, state of mind.
Grounds for your objection. Seriously. And it's also already in evidence. Your Honor used the recording of the conversation.
What's your goddamn objection?
What did he say to the officer?
I did not hear what was said.
Next question.
What did you see as far as any physical gestures by either Mr. Carney or the officer?
I saw the officer lift his hand and point towards the registry of deeds. I then
Next
saw.
question.
And then what did you see Mr. Carney?
That's what Jason was talking about yesterday. Cosgrove going objection, objection, and she's like, the question that was asked her was, "What did you see going on?" And he's like, "Objection, hearsay."
Carney do in terms of gesture?
I saw him do the same.
And where did you see Mr. Carney proceed after that?
He then walked over to the registry.
Was he still doing his thing with his phone?
Yeah.
At some point, hundreds of people stream out of the Norfolk Superior Court, right? Was
There's
it
Jason there.
close in time after this interaction?
It was.
What did you observe about people streaming out of the court?
Just generally, I really didn't, or I don't know.
Okay, was there a large number of people or a small number of people?
There was a large number.
Now, were they going towards the handicap ramp, down the main stairs, or where were they going in general?
There were folks using both the handicap, handicap rail and the.
Did you, were you near Mr. Carney when those folks started to stream out of the courthouse?
No.
Did you see Mr. Carney doing anything else outside the courthouse when these folks were coming out of the courthouse?
I did not.
I just have one more, please, Ron. Thank you very much, Ron. Nothing further. Thank you.
So he friends
I had seen his YouTube.
just once.
No.
When was the most recent time? So.
Last night I had one of the jurors from the first hearing trial.
Have you watched others as well?
Yeah.
You have a paid subscription to any of these channels. Some of them are free, some of them are paid.
No.
And can I ask you if you executed this affidavit as far as
Yeah.
and how did you come to run this affidavit, or how did you come to execute this affidavit?
I cannot recall if somebody sent me a tweet or if I saw it myself, but it was basically a request from Mr. Carney. If you were there, let me know if you're going to.
So he put out the request and you responded to it?
Yes, I felt.
Don't tell me what you thought.
Yes.
Answer the question. So,
Getting hot over here.
After you responded, what happens if you're still approved?
I sent it over to, the paralegal who works for,
Did you draft the whole application yourself or did the paralegal before you work?
I drafted it mostly myself. She had other parts of it that I had originally drafted.
All right. And then you read it over and signed it?
Yes.
So some of this language like I am of age and resident of Commonwealth of Massachusetts, that's not your language, right?
Objection, Your Honor. Legally, she signed it and adopted it. It is her language.
Overruled. Do you understand the question? Were you the one that wrote that, or was that suggested writing that you signed?
I wrote the affidavit.
Thank you. No further questions. I think I'm.
Nothing further. Thank you.
Your excuse.
Thank you.
Congratulations.
Court's in recess until 2 o'clock.
All right, continue to the front door. Thank you.
Zoom will resume at 2 o'clock. Thank you.
I'll tell you at 1:45. You guys are okay with that?
Yeah, of course.
Right, Meredith's testimony.
Would you raise your right hand? Do you swear in the matter now in hearing to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
May I inquire, Your Honor? Good afternoon. Good name, spell your last name. And where do you live, ma'am, just generally? What do you do for a living?
Yeah.
And who do you work for?
I work for Large Training.
And what's your educational background?
Management and French, and then the master's in accounting and MBA from North University.
How long have you been an accountant?
So, 12 years.
And do you know Wade and Carney? How do you know Mr. Carney? And how long have you been dating? How long have you known him?
Years.
You know that he's charged here today with violating a restraining order, right?
Yeah.
And you were with him that day, weren't you? Tell us how that came about, that you and he were together and coming here on coming to Dedham on 2/26/24.
Sure. There are motions that again these we both have obviously been following the trial for quite some time, so we decided to attend the hearing together.
And just for the record, so the factual background is clear, Mr. Carney is probably the most prolific commentator and journalist investigating on the Karen Reed case. Is that a fair statement?
Overruled.
Yes, that's a fair statement.
And you actually do too, right? You
Yes.
comment on Twitter or X about it here and there, right? And you assist him with that endeavor as well?
Yes, sometimes.
Sure. So on that date, there was an afternoon hearing on the Reed matter, right? And at the time, Mr. Carney had just gotten out of jail a couple days earlier, right?
Yes.
And that was from a case that was out of this court, right? You know a little bit about it, right? And that you know that the charge in that case was among the charges in that case was a charge of assault and battery, right?
Your Honor, this is Mr. Brady's witness.
I'm just trying to move it along for some preliminary matters, Your Honor.
It's leading, but it's all anecdotal. We all know most of this anyway. Let's go.
Of
So-
course it's leading. We're not in
On
freaking.
the day of 2/26, how do you and Mr. Carney come together?
So court together with our friend Brad Holtz.
And what was the plan that day among you guys to watch this hearing?
So, we're on it. And we got there another one.
Where did you park when you got here?
I parked the right.
And did Aiden have a car in some other location as well?
Yes, about 5 or 10 minutes down the road, he in park, so I met him coming from his house and then we drove together.
Then you drove together closer.
Close, correct, to the Red Street.
And where did you park your car?
In the Red Street parking lot.
So in like the back of the building, behind the building?
Yeah.
Did he leave some items in the car when you guys departed the car?
Yes, his computer and his car key.
So what was your path, the three of you, what was your path to the Norfolk Superior Court?
Into the courthouse, we walked around, I believe this building, between this building and the registry, across the street, and crosswalk, we crossed up around 1:30.
Was there anything unusual that occurred in the walk, or was it just the typical assemblage of people outside?
Not at all very typical. Orders Karen and bees outside.
And did you have some conversation with them, or did you see Mr. Carney having any conversation with them?
Yes, many conversations.
Do you know who Lindsay Gattani is? And did you see her outside anywhere during your arrival into the courthouse?
No.
What happened when you got into the courthouse?
Well, about 1:30, we weren't letting go in the steps, so we went to security and then went upstairs and waited in the line before they started letting people in about 10 minutes before.
Did you and Aiden and Mr. Goldstein, did the three of you get into the court hearing?
Yes, we did.
And where did you go when you got in there?
That is the third, towards the outside. So.
And if you were looking up at the bench, at the judge's bench, were you on the left or the right?
We are on the left.
All right, so kind of near the windows on the left. Did you sit in the same row as Mr. Carney or a different row?
Same row.
What time did you sit down roughly, if you remember?
But one would have been 1:50 or before the start time.
Did you have any knowledge of the hearing that was about to commence and what kind of a hearing it was?
Yes, it was a motions hearing. There were several motions to be heard, including a vote.
So was this the type of a hearing that you anticipated would be 5 or 10 minutes, or a longer type of a hearing? So you were sitting down. Did the hearing commence at about 2:01 in the afternoon? And right around the time that it commenced, did you see Ms. Gattani? Where did you first see her? All right. And just to summarize, you've seen video of this and you're aware that there's video and evidence about this very snapshot of time, right? Okay. And you remember it though, right? All right. So we're going to just go with your testimony. So when you turned around and you saw Ms. Gattani, what did you see? Set the scene for us.
Right away, identity, and right now I'm being out in cave and some other family members. So we noticed that the car and was trying to that once he's here, we usually found.
Did you notice whether she had anything in her hands? Did you make any eye contact with her or communicate with her in any way?
No, as soon as I saw her from afar, I did about him.
When you turned around to see Ms. Gattani, you were looking kind of towards the back of the room?
Yeah.
You kind of had to turn over your shoulder. What about Mr. Carney? Did you see him, whether he was looking with you or whether he was looking straight ahead?
It was not her. I was just looking to see who was coming in, just wanting to see if it was the judge gave it to other witnesses that he.
Okay, just listen to the question you're asking. Just answer that question and then just wait for the next one.
So when you, right at this snapshot of time, when you're looking back at Ms. Gattani, you see Mr. Carney. Did Mr. Carney react in any verbal way, to your knowledge, when he saw or you saw Ms. Gattani?
No, correct.
Did he get up?
He did get up and said, diabetic.
Was he facing the direction of Ms. Gattani when he said that, or was he facing the direction of some other people in the rows?
Stay forward.
And what happened next? Right next.
Got out. Also standing in there between us, grabbed standing between us, when we left, walked out the door, and downstairs.
Did anyone have to tell you or Mr. Carney what to do?
No, I told him to leave me left. I'm speaking it for him.
What What was the time period that went by from the time Gattani walked in the room till you and Aiden had walked out of the room? Where did you see Miss Gattani go when she came into the room, if you saw her?
I did, like,
Did you see, do you know who Paul O'Keefe is? Did you see Mr. O'Keefe in there? If you remember.
don't listen, I mean, looking at videos after the fact, and I can't say that at that time, when I was walking out, I saw any of them because I was just focused on getting out.
In the 10 minutes or so that you were waiting there, can you recall looking around the courtroom and seeing who was around?
I think somebody has been there before, but certainly not Mr. Tanya or Jeremy Gage, who walked out after that.
So you leave with Mr. Carney out the door of the courtroom.
Correct.
Where do you go?
We head down the stairs, security area where we came in, and a couple people
It
stopped
seems
us.
like most of the testimony came from Meredith.
So you walk outside and you're going to leave the courtroom?
Yeah.
As you guys leave, did anybody from the Alberts or McCabe's or O'Keefe's make any comments about you or Aiden having to leave?
Objection, relevance, overruled.
What did Chris Albert say?
That's the ITP talk that we did.
Where did you go, just physically, where did you go when you left the courtroom?
Right downstairs.
Did you speak with anybody as you were leaving?
One woman, Eden.
Okay. What was Mr. Carney's kind of demeanor when he was leaving?
Objection to the characterization and to what he wanted.
Or the anxiety stays, the rest doesn't. It's a question.
When you say he was in a state of anxiety, can you give us some things that you observed about him that made you conclude he was in a state of anxiety?
Well, yeah, he was anxious.
He told me.
That might be a good sign.
So you get down the stairs to the first floor, and what happens on the first floor?
A woman approached us and gave some information about entering the courthouse before.
Do you know that lady by any chance?
Yes.
Was that in the vicinity of the metal detectors, or where was that on the first floor, just generally? Did you stay with Aiden for that, or did you go ahead of him, or were you still together, or what? You exited the the front doors of the courthouse? And what was the scene that you first saw when you went outside?
There was a smaller crowd of people outside, smaller than a lot of people are gone to the hearing, but for these young people, were also police officers.
Approximately how long after 2 o'clock were you guys standing outside?
Probably within 2:06.
A few minutes after 2:01 or so, a few minutes later. What did you see Mr. Carney do when he came out of the courthouse?
He immediately walked up to a police officer across the street.
And where was the police officer?
Directing traffic in the crosswalk.
Okay, so that's kind of is that a busy area there, or is that a quiet area? So did Mr. Carney stay on the court side of the street, or did he walk to the registry side of the street?
He walked to the registry side.
Did he try to have a quick conversation with the officer?
Yeah.
And what did you see?
The officer, things restraining order to completion, the officer said, go over there for now.
And did you see any physical gesture that accompanied that statement?
Pointing towards her.
Okay, so he kind of made a physical gesture pointing in that direction. And did you see Mr. Carney do anything in response to that gesture?
He went over towards the registry, the actual building.
All right, and did he, where did he stand in relation to the actual facade of the Registry of Deeds building?
He was all the way up against the wall, far away.
Okay. Did you and Mr. Carney intend to do anything at that time period to memorialize what had just happened inside?
Action to what she
Yeah, objection sustained. It's to the form of the question.
Sure. What was the plan between you and Mr. Carney about what to do about what happened inside?
Again, I memorializing what happened in there to ensure that this could happen, even going to see what happened and make it found to be some type of violation.
At some point, was Mr. Carney reporting, doing his job, I guess, about what had just happened to him?
Yeah, started live stream of the courthouse, and we both agreed it was a good idea, so that every day was documented in case we could came back out, all of those.
And what is live stream?
It's just when you have the camera and you project a live video to an audience, whether it's YouTube or platform.
Was Mr. Carney live streaming, to your knowledge, as he came down the courthouse steps? Was he live streaming when he was talking to the officer?
Yes.
Did he continue to live stream as he followed the directions of the officer? When he got to the facade of the registry, was he still live streaming? All right. Did you want to get involved with him in his live streaming at the time?
No, I purposely kind of stayed out of the church that
At some point, did hundreds of people stream out of the courthouse? How much time had passed between when, let's say, when he gets to the facade and then when hundreds of people come out of the courthouse?
probably March.
Was that an expected strikeout? Was that the departure of the folks that you saw in the courtroom earlier?
Yeah.
Did you expect that hearing to end, causing all those people to leave?
No. Still in there, with us.
You mentioned that the officer that Mr. Carney spoke with was in a little bit of a busy area, right? Did it get less busy or did it get more busy when those hundreds of people came out?
We got more.
With this event occurring, did it get more difficult or less difficult to get the officer's ear to get something going with respect to the police report? And was Mr. Carney continuing to live stream?
Was for a period of time, yes, that it, yeah, so.
Did many of those hundreds of people kind of come across the street to the registry?
Yeah.
Do many of those people know and communicate with you and Mr. Carney? And they do typically on a regular basis. These are people that you guys know, supporters, friends, colleagues, acquaintances, right? Did you and Mr. Carney kind of separate off from each other in terms of talking to these people and doing whatever you guys were doing?
Yes.
And where were you and where was he, to your knowledge?
Still around that same area, there's around to where the officer is. So at one point, my friend Brad, my team was, but he wandered a little bit towards the parking lot.
At some point, did you see Lindsay Gattani and her group come out of the courthouse? Was it something that was open and obvious, or was it something that was mixed in with everyone else coming out? Was there something unusual about, the colors? Was there contrasting colors? Was it a majority of similar clothing, or what was the scene?
A lot of them started wearing black.
Did you, at some point when they came out, when Gattani and her group came out, were you paying attention to Mr. Carney at that time?
I don't know exactly, but the only time I saw her was when I went back to my car parking lot to try to get stuff there.
So before you left, did you, and when you were in the vicinity of Mr. Carney, did you ever hear him calling anyone a liar, screaming out liar, liar? Did you ever see him make any outward manifestations that he had seen or spoke to Ms. Gattani?
No.
And was he still live streaming?
Yes.
When you live stream, do you hold up your phone in the similar fashion as you would when you're videoing someone or photographing someone?
pulls it up. People follow up.
So just, is it a similar way or is it dissimilar?
It's different. Really trying to get yourself.
And was he doing that to your observation that day? So you were able to discern that he was holding it towards himself versus memorializing the scene. At what point do you and Mr. Goldstein decide to go head towards the rear of the building?
Hi, Micah.
He gave it down, he got it, and then he went to my car because he left his school there.
Okay. So, did you say that you saw Ms. Gattani in the back parking lot?
I did, she was already there by it. I didn't need to see her. Brad, when I stepped out of my car, Brad pointed out that there she is, and it took me a few minutes to even represent to be able to recognize her with another group of women and pretty much wearing the same thing, so it just took me a lot far to see her. But
She was parked all the way at the far end of the registry of deeds parking lot, right?
further towards the end than I was, yeah, and I was closer to that level.
More than a football field away from the registry building, or about a football field, or less than a football field from the registry building, from the back of the registry building? So she was almost to the back of that registry parking lot?
Yes.
Was the rest of her group also parked there and congregated there?
We were all congregated there, and the other part, but they were.
So if Mr. Carney, when he left, if he had gone to the back of that parking lot, he would have been going right to where Gattani was going.
Sure.
It was the same location as where Gattani went, right?
I got the picture. Next question.
When Mr. Carney went to the back with you, was Gattani still there or was she gone?
That was much later, no, I went back and found him. When I saw her back there, I needed to text him and said, do not come back here.
Okay, so then you go back to where Mr. Carney is?
All the way on court. To the right of Superior Court where Sharon and her team are. Down that way, so.
All right, so he had departed and gone the other way? And that would be, as you're looking at the North Superior Court, the street to the right along the side of the court, right? And you went and found him? Did you bring him his items? When, Ms. O'Neill, is the first time you saw Ms. Gattani? Departing the court. Did anyone in the group appear to be agitated or upset by anything that may have transpired? May I have one moment, please? Thank you very much, Ms. Nothing further. Cross-examination.
You know, I think you told Mr. Brayful, no, back for a couple of years and that you've been dating, 8 months, that's right.
That's correct.
You know when he was dating this time?
Yeah.
Really? You don't much like Mr. Time, do you? That wasn't the question. Did you hear the question?
Yeah.
What was the question?
Do I like Mr. Tony?
Yes. Now try my question.
Of course, I don't think so.
He's so rude in this costs.
Did you execute an affidavit, Ms. O'Neill, on June 5th of this year? And did you say, Ms. O'Neill, paragraph 3? Actually, I'll show it to you first. And you can ignore what I circled. Take a minute to read that.
Number 3.
Yeah, just read it to yourself. So did you say in number 3 of your affidavit at approximately 2:05, I turned around and saw Lindsay coming into the courtroom holding a white piece of paper in her hand. Immediately told me we need to leave. We were surprised to see her there because she never attended parent briefing prior to that and was not friends with any of the witnesses or victims' parents. By the way, have you attended all of the parent hearings at that point?
Most of them, not all.
And you don't know of your personal knowledge whether this good time you were setting it already previous service or not, do you?
I do watching this. I watched every single hearing.
Oh, you kept a vigilant eye. So that the moment that Ms. Catani walked in, you checked out every single person in the courtroom?
Well, at that point, she said,
Yeah, it was just her that we were worried about. Not
I'm sure
everyone
I see
in
the
the courtroom.
connection, but maybe if I think about it, it will become clear. Now, did you happen to read an affidavit that Mr. Kearney wrote?
Mr. Carney wrote. Is it, if it's her
Does
affidavit?
I object to impeaching a witness with someone else's statement?
See what the question's going to.
Well, I'm not familiar with all of it, but there's a lot that think like that. Also, take a look.
Just wait for a question. You don't have to respond.
Did you happen to watch, did you watch all of his training shows? Do you remember whether you
No, but Lindsay
watched the
does.
Saturday Night Live show on February 24th?
That's what I would have said.
I don't remember off the top of my head, but that was so long ago.
Well, can we agree that February 24th of 2004 was 2 days before February 26th, the Euro Day of Space?
2024?
Yes, right, right.
Yeah, thank you.
Thank you. And do you know that Mr. Kearney said that on that live show, the amounts that he would be defending Karen Reed here was for that.
You're saying that very nuts.
And do you know that he stated that,
Give me one.
You what
Witnesses don't
now?
have to agree or
What
disagree, just whatever you know or don't know.
and you know that he stated that on that show, he expressed concerns that some gangs and outlets would show up. with
No idea,
a
Joanna.
human shield
I know he
in
got
order to
paid a
remove
lot.
him from the courtroom due to the restraining order she had.
Government contracts always pay good.
Well, still for the moment, he did. Can you explain why, in light of the fact that he's broadcasting on the live show 2 days before the hearing, he was worried about the family showing up? He was surprised to see Lindsay walk into the court.
Objection sustained. No, excuse me. Objection is sustained. Next question.
So you and Mr. Kearney see Lindsay your time is come in and you get up and you go down the stairs and out the door of the boat. Is that correct? And at what point Is Mr. Kearney style live? Yes.
You have seen her speak something outside.
Stepped outside the courtroom or stepped outside the building? Okay. And that was always the plan, was it not? What's the point of the visit? Was the Kearney was going to do a live cast on the scene?
I don't know. He's managed to
Did he pretty much always do that? And that was the camera meeting?
before, I won't look after it.
Yeah, he's got to have a moment. Here's the thing, though, you know, D.A. Morris has always got to have a misogynist batting for him. It's fucking nuts.
Camera on him to document what's happening out there.
He told you, I want to document what happens there.
That's the time he followed him, he wanted it on camera.
Oh. So you're outside of the courtroom, he talks to the officer, and the officer directs that you say registry. You hear the officer say registry of deeds.
So he said go over there and point the registry of deeds.
Oh.
If we're lucky, Jason can pop in and say hello.
Pointing at the building.
Straight ahead.
Absolutely.
Wasn't pointing at Ponson.
I want to punch.
Mr. Kearney goes over there. Are you still with him at this point?
Yeah.
And are you standing next to him or nearby him by the registry of deeds building?
Bye. Not sure.
Oh. And you're familiar with the Norfolk Superior Court, the entrance and the exit, I'm not. And you've attended a number of the hearings that you've seen. And you know that typically when the hearings get over, people who have attended the hearing, quite a number of them can't read your that.
Sorry.
Would you agree that quite a number of people typically attend Karen Reed hearing?
Okay.
And on this particular day, it was so crowded everybody couldn't get in, right? So you know when the hearing ends, what typically happens.
He's so much like
people
Hank
go
with
out
kicking
that
dirt in
main
his own
exit
face.
door, same one they went in, right?
Yeah.
Now, at some point, you notice that people are coming out the door, right?
I wonder who to, Joanna.
Standing next to the defendant at that point.
Or a little bit, you're still a little bit away. The crowd started.
Oh. Well, did you observe whether Mr. Kearney, who was worried that Mr. Kearney might follow him, was looking at his jeweler at the door, was in the position to notice the crowd coming?
On his camera live streaming himself.
So is it your testimony his view was totally obstructed by the phone?
I can't tell you what he was thinking at that point, because I was having a conversation.
Well, you've been very good about telling us when I'm soaking it up. Counsel, should you wait for her to answer the question? Thank you.
Take that.
I can't tell you what he was thinking about his assessment of what was going on. I was having a conversation before rushing up to me.
So in any case, you noticed that people were coming. Oh. Did you have any reason to believe that Ms. Katani would not be coming out that door with the rest of the crowd attending here? What was the question on that? No. I asked you, did you have any reason to believe that Ms. Katani would not be walking out that door with all the rest of the people who attended the camp?
Objection, or is inviting speculation, someone else's state of mind.
True,
I'm
eh?
sorry, I didn't mean wrong for insisting. Well, at that point, did you say to Mr. Kearney, I see people coming out.
I see dead
I
people.
see people from the Karen Reed hearing coming out the door across the street. Did you say that, John? And you're only talking when you're directly next to.
I was talking to other people.
So you have no concern at all
Maybe.
for Lindsay Gattani to come out and pursue him and get him in trouble.
Maybe.
You weren't worried about that at all at that point.
I was trying to figure out what happened because
I didn't ask you what you're trying to figure out. I asked you if you were worried at all that Lindsay Gattani would come out and pursue him. I thought that was your big worry. Did you tell Mr. Brady that? You and Mr. Frank were
I
very worried.
just would like her to be able to get an answer and.
One question at a time, if the possible.
Or she just needed this guy.
you're too crazy about that. Or next time, look them up.
And you don't think that, and believe this one, please.
She will send her to me.
No, I didn't ask you why. So you don't tell Mr. Kearney that people are coming up, you don't call that the other catch. Because you're talking to somebody, or for whatever reason, you don't call it to this. And you don't say, hey, Lindsay might be coming out that door. Why don't you go back to my car and get the hell out of here so she doesn't track you?
Because that was the point, you fucking moron. She was trying to get them
So was it your plan
chased
to
them
wait
out of there.
until she was on top of you before you left?
No, we didn't have a plan to be expected very much in 5 minutes.
Well, it hasn't, right? People were coming out the door regardless of your expectations.
Why didn't you run away in fear like she wanted?
And in fact, before people even started coming out, you were so worried about it. Why didn't you say, let's go back to my car and get the hell out of here so there was some problem?
Why should you more than support that?
Because we were there first, moron.
Police station in the town of Devon. And you know when Mr. Frank filed a police report? Relative to that visit.
Excuse me.
Couple of days after.
Sorry, I didn't mean to do that in the speaker.
So you couldn't leave because you wanted to file a police report, but then a couple of days passed before Mr. Kearney gets there. That what you're telling us?
At that point, this had already started with this, so.
But you think it would have been approved to get it recorded before she did?
He did, like, that night, so.
So you would say she was very quick about reporting the alleged violation?
He's still kicking sand in his own face here.
Could have belonged to. Yes.
Like he's a little bit more subtle about kicking the sand in his own face than Brennan, but he's still doing it. It's like, where does Morrissey find these people?
Mr. Kearney did not stay up against the wall of the registry of deeds. Yeah.
No, we actually went out to the down Court Street, like this guy texted them, "Do not come back here in the parking lot."
Well, when he starts moving, he moves in the direction of this court, correct?
Here, let me see if I can put some more sand
Down Court Street.
in my own face.
Really?
Could I have,
Wow, it almost did sound like Brendan then.
15, please?
Let's
Do
show.
you remember what Mr. Kearney was dressed as that day? Blue
Dress.
tie, dark blue tie. You seen in that photo, towards the back? Well, at that point, he's not in the front of the, he's not on the steps of the registry of deeds. All right. Well, would you say, looking at the registry of deeds building, would you say he's moved to the right or he's moved?
Judge, I object. This is all speculation because we don't know where Mr. Connie is. We don't know when this is.
Objection sustained. I don't need to give a open. Can you tell from that photo what direction he went? Yes or no?
No.
Next question.
All right.
Moving right
Let's
along.
look at 16, please.
I think I like this judge. Like, he's pretty straightforward. Like, stop fucking me around.
Well, wherever he is, it's fair to say he's not on the front of the registry of deeds at this point.
I can't tell where he is. I don't, it doesn't look like the front of.
All right. Let me move on to another line of question. You had your cell phone then. Spring obviously had his cell phone. If you ever call him and suggested that you should have a call.
I did not serve it there.
Sorry?
I didn't call him, but I went down down for just a minute.
Whenever you're in the courthouse or whenever you're outside.
That is your general. I can't do terrible service.
Where's your carrier?
Thank you.
And when you were there were a lot of people in the crowd shouting this. And you were, at times, you were some distance from Mr. Kearney, you know?
Yeah, and then we went back to the parking lot.
Right. So you really have no idea whether he happened to shout liar, liar at somebody at that time or not.
Well, by the time I got to the parking lot, Mr. Connie was there, so we couldn't have got.
And when you were apart from Mr. Kearney, were you down in the parking lot the whole time, or?
For most of the time, and then walked back, yes.
So you weren't necessarily next to him at all times before you got to the parking.
When the parking lot, we were most of the time.
I'm sorry?
Before I went to the parking lot, was when we got separated, I was with them most of the time.
You were most of the time fairly closely. All right, so the answer to my question, which was you weren't with him at all times, is yes. Let us have a complicated then.
Not in here, but outside, yes.
Still have the text message, do not come back here.
I didn't scroll that far, but if I didn't delete them, if I would see that, would be in that.
All right, thank you. No further questions.
Just a brief question, Your Honor. So you were asked Ms. O'Neill about why didn't you go find the police station and report it afterwards? Something to that effect, right? Were you in the car with Mr. Carney for a little while after kind of this whole thing had subsided? Was he in any sort of state of mind to be able to report anything to the police?
On the very secure, I mean, go get it.
I'm sorry, I didn't hear you.
He was on the brink of tears, he was shaking, and his movement. Trying to calm him down enough to be able to go, at least pick up the kid.
All right. And is that why you didn't pursue any police documentation at that point?
All he was. So.
Thank you. Nothing further.
Yes, right. And from the break of tears and the, yeah, I don't think that's fun. Jonathan crying during the live broadcast. The live cast he was doing across the street, Registry of Deed. So he only collapsed into this emotional state after he hit that. He held it together bravely during the broadcast. No further questions.
No further.
You may step down. Thank you.
Judge, that's the break. I have a very quick witness who's got to pick up her kids, and I was hoping to maybe just get her on for 5 minutes or so.
That happened across, but we'll start it.
Sure,
Go for
appreciate it.
a short period of time.
Thank you, Lauren Cologne. Lauren Cologne.
Or go well.
Lauren Cologne.
Yep.
Yep, thank you.
Good morning, if you raise your right hand. Do you swear in the matter now I'm hearing to tell the truth, the whole truth, and nothing but the truth, so help you God? You do. Thank you.
May I inquire, Your Honor? Ms. Cologne, good afternoon. State your name and spell your last name, please.
O-L.
And where do you live, just generally?
In the Northport County.
What do you do for a living?
I am a project manager at a large company. I work out of their headquarters.
And are you married?
I am.
Family? What's your educational background?
I have my undergraduate and an MBA degree, both from Northeastern University.
You've taken an interest in the Karen Reed and Aiden Carney cases here in Norfolk County?
Yeah.
And from time to time you attend these hearings?
I've attended one hearing.
Was that 2/26/24?
That work.
And you were there inside the courthouse or outside the courthouse when that Karen Reed hearing was going on?
Okay.
Shortly after 2 o'clock, were you outside the courthouse? Do you know who Aiden Carney is?
We do.
And it's the gentleman here with me, right? And did you see him emerge from the courthouse a little bit after 2 o'clock?
I did.
And what exactly were your observations? And first of all, where were you situated when you first saw him?
Yes, I was on the stairs. It was the first stair or two leading up to the courthouse doors.
Okay, so the base of the stairs at the Norfolk Superior Court main entrance.
Yes.
You see Mr. Carney. What do you see?
Mr. Carney came out. He looked visibly anxious, very, very anxious. He had really a great concern that was.
Direction. Anxiousness, Jan, that's a question.
Was he using his phone at all?
But then I did.
All right, we did her.
Comment that I should.
Who's next?
The story. And what were you referring to in terms of that?
Because I didn't know about the story, like everybody, they put it on the news that, 4, 5, and 7, they talked about it, but then went away just as quickly as it came. And my sister had told me about it.
Closing arguments.
Sure, I'll just ask you. Appearance back in the case after getting sent to jail on her charges of assault and battery in this court. She came in there and she was ready with her restraining order for one purpose and one purpose only, not to be there for the Karen Reed hearing, but to evict Mr. Carney, to cause a to try to cause a restraining order violation. And I appreciate the Commonwealth saying it. Mr. Carney did the right thing and he left. It was about 19 seconds, if you look at the video, and I know you have 19 seconds between the time when Gattani went in the room and Mr. Carney went out of there. He didn't say the F word to her. He didn't look at her. He didn't do anything. He didn't need a court officer just to get out of there. Those are all things that Gattani said happened. They are all completely belied by the video evidence. None of it happened. So that tells you everything you need to know about the credibility of Gattani, Your Honor. She was there to evict him. And we also know that because of her own testimony about this bus situation. She claims that she that she had to get her kids off the bus, that she had some other person getting the kids off the bus. Everything is just an ever-evolving story with her. And whenever she gets back into a corner, she brings up her children. And in this case, Your Honor, we know that she had to get home to get her kids off the bus at 3:10. So she was here not to sit around all afternoon and watch the 2-hour anticipated Karen Reed hearing. She was here to evict him from the courtroom and then get out of there because she had to get home to get her kids. She tells this ridiculous story that somebody else was going to get her kids off the bus. What responsible parent would have someone who the kids never met waiting for their kids at the bus stop? Oh, that's the rule number one that you tell your kids is you don't ever go to somebody that you don't know. And I think that's a complete fabrication after the fact concoction of a story, Your Honor. Yet another one of those. So in this case, Judge, Mr. Carney leaves immediately. He does the right thing. He goes to the government. And this is a significant legal fact, Your Honor. He went to the police and he said, where do I go? I have a restraining order. You have it on tape. You saw what happened. That never happens. We have it here. He recorded the conversation. It was live streaming. And the officer said, go over there. Gestured up to the registry. Go over there for now, actually, is the full quote. He goes to the registry. He hangs out as far up against the building as he can get. He's waiting for further action. He's waiting to report things to the officer. Why? Because of the Frank Keegan situation, which you saw in Chambers. He knows what this person is capable of. And he's in the middle of it. She just chased him into his place of work, into the courtroom. He leaves, does the right thing. He goes outside and he wants it documented. He doesn't want to disappear and run into her. He doesn't know what she's capable of. He probably doesn't even quite have a rational appreciation for what she can and can't do because she's already sent him to jail for 60 days. He just gets out and she's trying to get him right back to jail, walking around with that restraining order, showing up to places she has no business being at, showing up to get him in trouble just 3 days after he just gets out of jail. He's shaking, he's angry, he's scared, he's upset, he has anxiety. He's trying to get away from her. So he goes to the representative of government, of the policeman, and says, here's the situation, 100 yards, where should I go? He gets sent up there. He's not a drone. He doesn't move as the crow flies. He goes down the steps, around the corner. He takes a circuitous route down the steps, across the street, and up some more steps. He's trying to comply with what the officer says. He's waiting there for the meantime at a safe location so he can report it. He's not engaging with her. He's not bothering her, whatever. He has no criminal intent, none whatsoever. And so if the alleged violation is later on, there's no knowledge and there's no contact because he has no knowledge, no intent, she has no knowledge or intent he's there either. And her assertions are A, lies, and B, after the fact concoctions when they get back to the car and her co-conspirators, her compatriots look through the video and say, oh, there he is. All right, we have him in business. And they're also trying to get him on this claim of automobile damage, where we know from the circumstances that he could not have done that. There's zero evidence he had anything to do with that. There's zero evidence that is even something that is a fresh situation. And Gattani has absolutely no credibility to believe that this may have just happened right there. We don't know when that happened. There's no evidence. There's no fresh damage. There's nothing to that. So they're trying to get him on this phony motor vehicle thing. They're trying to get him on this setup of a restraining order violation, Your Honor. So All of this occurs, and Mr. Carney is live streaming the whole time, meaning he's talking into his phone. He has his phone up. He's upset about what happened. He's reporting about what just happened to him. Meanwhile, the hearing ends early. Everyone streams out. You see the video. It covers the whole front of the Superior Court. So many people have black coats on. The women, black coats, black hair, black sunglasses. You look, it's a sea of people. It's reasonable and likely and probable, and it did happen, that Carney was live streaming and looking around and didn't see Gattani. Gattani registers no perception of Mr. Carney. Gattani's walking along. Gattani never once gestures. There's never one bit of looking, pointing, call 911, telling her friends, nothing about Mr. Carney being there. She doesn't see him. He doesn't see her. That's no contact, Your Honor. At a bare minimum, the government doesn't come anywhere near proving the case beyond a reasonable doubt that there was contact. And they have to have knowledge to have contact, Your Honor. Gattani went out of the courthouse and was walking away from the building, Your Honor. She's walking away towards Dedham Center, and then she turns and she's walking away towards the parking lot. So even if there was intentional contact, which there wasn't, she was walking away. And so whenever there's accidental contact, you can't just beam yourself up to be automatically, immediately 100 yards away. If you see the person leaving, they're leaving. The situation is getting to where it needs to be. And he has a due process right that there be time that elapses for him to get into compliance. And if she's leaving the scene, compliance is being effectuated. It can't be something that's instantaneous. And of course, Your Honor, the most important thing about this is that Gattani goes to his orbit, not once when she goes to the courtroom, but twice when she goes outside. Mr. Carney has no idea what's going on. The hearing was prematurely over. Everyone anticipated a long hearing. And Mr. Carney wanted to report it to the police. He didn't get that chance because everyone streamed out and the officer was already busy directing traffic in the walkway. So that's the entire factual scenario, Your Honor, where you see cases that come through here every day with respect to restraining orders, where people are trying to get to someone, trying to knock on someone's door, trying to show up at their work, trying to bother them. This case is the exact opposite, Your Honor. Mr. Carney is trying to get out of here. He doesn't want anything to do with her. He's got, obviously, from his anxiety and his upset, he's got some major post-traumatic stress disorder from this woman. And he doesn't want anything to do with her. And she is trying to effectuate this violation. She's trying to chase him down, just like she did to Frank Keegan, to get him arrested. That's what she does. She's not a person of good character. She's not a person of honesty. She's a person who strives on chaos and trouble and harm. And that's what's before you, Your Honor. And the last thing I want to suggest, Judge, is that imagine a scenario where this kind of conduct is rewarded by a court, is implicitly allowed to be a restraining order violation. What a message to send to people with restraining orders, that you can use it as a sword. Go find the guy and create a situation. And that's what Lindsay Gattani did here today, Judge. That's what the evidence showed here today. So I ask that you find Mr. Carney not guilty. Thank you.
Well done, Mr. Bradle.
Well, the defense has done its best to make this trial about
his way through it
conduct rather than about the defendant's own conduct. But that is not the case. I don't know that I need to repeat the arguments I made to you, Your Honor, on the motion to direct a verdict about the Commonwealth having proven each and every element of this case. But I do want to review the evidence and suggest some inferences that you could fairly draw, and I would suggest you should draw, somewhat different from those suggested by Mr. Bradle. I'd like to start with the restraining order itself. Can we have number 27 on the screen, please? Sorry. Number 2, you are ordered not to contact the plaintiff in person, by telephone, in writing, electronically or otherwise, either directly or through someone else, and to stay at least 100 yards from the plaintiff. And these words are important, Your Honor. Even if the plaintiff seems to allow or requesting contact.
Agreed, Bob. Agreed, totally.
Bridal probably referred to the fact that Your Honor has seen these cases before, and I imagine that you have. How many times have you seen a case where someone is brought in on violation of probation or violation of the restraining order, and the defense is, Your Honor, she called me up. She invited me over to the house. She said it would be okay if I came home. And all that's true. But it's still a violation of the order. It's still a violation of the order. Only a judge can modify a no contact order. Not, I think Mr.
Careful what you wish
Attorney's
for.
words, I hope I'm quoting correctly, were some meathead cop. I think he said you can't hide behind some meathead cop, but apparently Mr. Kearney believes he can hide behind some cop. But a police officer, or at least Mr. Kearney's interpretation of what a police officer said, can modify restraint. And I suggest to Your Honor that if calling somebody up and specifically asking him and inducing him to violate a restraining order is not a defense, is not an entrapment defense. And there certainly isn't an entrapment defense that arises from somebody walking into a room. In fact, we know what the law is with this sort of accidental contact. The law is the person is to leave and make prompt and reasonable efforts to bring himself in compliance with the order. The order is 100 yards. He started out fine. He got up and he left the courtroom. All he had to do, Your Honor, was keep walking and put 100 yards between him and his guitar. But now we get the.
So you're saying
the alibis.
It's okay for her to use
never puts 100 yards between himself and his guitar. Well, one is, I checked with the government. I did what the police officer directed me to do. Well, you heard the clip and you heard the officer's testimony as to his perception of what happened.
It's
Mr.
cold.
Crane comes out and says, first thing he says, I want to put this on record. Why does he want to put it on record? I suggest in light of both that comment and what you've seen in the rest of the trial, you could infer that Mr. Kearney wants to put it on record because he's setting up his alibi. He does not want to leave. He wants to stand there and make his live cast and denounce Lindsay Quintani and complain about how he was forced to leave that courtroom.
And
because he actually thinks it's his workplace. Oh, you heard it from Mr. Bradle. I assume the defendant endorses that. It's just, it's just like a mechanic in a shop. Well, Your Honor might have reached the conclusion that it's a public building. and that Ms. Gattani has every bit as much right to enter that public building and accompany her friends, whether old friends or newly made, as does the defendant.
But he was there first.
He talks to the police officer, and apparently, if we can believe the defendant's own witness, Mr. Carney, the police officer fortuitously suggests him to go exactly where he already told Mr. Carney to go. Walk across the street. I'll get 30, 40. Let's be generous. 60. No, it's probably too generous.
Me too.
However many yards away, and that'll be good enough. You know? I left the courtroom. I have it on record now. The police officer countermanded the judge's order. I've got a defense. I'm fine. So what does he do then? Does he stay across the street where he was, quote, directed to go by the police officer? Who, by the way, testifies he doesn't know who he has the order against. He doesn't know who that person is. He thinks he gestured toward Pond Street, I believe it was, and then the last he looked, Mr. Kearney is walking off in that direction. But Mr. Kearney says he's staying there because he wants to file that report. You might think his mind was on his live broadcast because that's what he's doing, not filing his report. And does he stay where he has been, quote, directed to go by the police officer? No. Does he even better get out of there, put 100 yards between himself and Mr. Khan?
Yes, he did, though.
No.
It's on camera, you dickhead.
Rather, he begins the process of following along when Mr. Khan exits the courtroom among a bunch of people. So he starts out right in front of the courthouse building, and then there's a progression. Could I have photo 14, please? When Your Honor looks at these exhibits, you can see that as the crowd goes down the ramp, he moves a little off the steps and up to the right on the cornice there, and then number 15. Now he's down on the ground in front of that tree, closer to across the street. And then number 16, please. Now he's moved further. He's got his camera up. He's supposedly terrified of what Mr. Conley is doing. It doesn't occur to him that if she's trying to entrap him, that maybe the sensible thing to do was for him to get the heck out of there. But he seems to be photographed. Is he live streaming? Maybe. Is he looking at Ms. Katani? Maybe. We've heard all this stuff about the various witnesses that Mr. Pareto called today, who immediately recognized Lindsay Gattani. And we know from Mr. Carney's testimony, I think, that he picks her out right away, standing across the street. He doesn't have any trouble seeing her.
Yeah, Bob.
I think it was him that I asked, was there anything about her that would make anybody standing across the street difficult to pick her out? No. Very conspicuous. If there's anybody who has reason to know what Lindsay Gattani looks like, Your Honor, it's certainly the defendant. But his story is, well, I'm not sure what his story is. Is his story that he didn't move, or is his story that he did move, but he didn't see Miss Gattani? Because Your Honor has just been told that it's reasonable that he didn't see her. Well, we have no testimony Mr. Kearney's not compelled to testify. He has the same right of any citizen.
Objection, none.
But I suggest that nobody else can testify to what Mr. Kearney saw or didn't saw. So Your Honor is therefore
Pick some
compelled to rely
Grace Cosgrove.
on inferences. And what inferences should Your Honor draw that a person who is well familiar with Ms. Catani and who is supposedly terrified that she is going to approach him and frame him and send him back to jail, and who follows her path as she walks down those steps? Oh, he didn't say that, he didn't know. Well, was he terrified and paying close attention, or was he not? It can't be both. It can't be both. And frankly, whether he saw her or not at that point, he's never removed himself. He's never removed himself 100 yards from where he first saw him. We have 28, please. That's the 100-yard radius from standing on front of the courthouse steps. You'd have to go to the other side of the Superior Court. Can we slide it up a little? Thank you. We'd have to go 100, the other side of the Superior Court, beyond Norfolk Street. Someone standing in, to get 100 yards away from where Mr. Kearney is standing, more or less. You can give him a couple of yards either way. No quibbling. And how can you move it down in the other direction? We'd have to go back well into the parking lot behind the Norfolk Registry of Deeds to get 100 yards of light. They knew where they were parked. The hearing was over. There doesn't seem to be anything particularly newsworthy about watching people file out of the courthouse. But Mr. Kearney was furious that he had been evicted from his place of work. And he was going to broadcast about that, and he was going to stay there. And who cares whether he got at that point within 100 yards of Lindsay Gattani and violated the order, because he had his excuses already and set up. By the way, I asked one of Mr. Kearney's witnesses, she wasn't much of a football fan, but she readily expressed the opinion that the difference between the front steps of the courthouse and where Mr. Kearney was standing, although I don't think she phrased it that way, I asked her the distance between there and the Registry of Deeds. Was it more or less than 100? Oh, less than 100. And she trusted the court that she was absolutely. Mr. Bradle says, well, there has to be a grace period. How long a grace period does he need? Is it a grace period to do a live broadcast? Is it a grace period to walk along parallel to this county film it? No, he was upset, Your Honor, in part because Miss Gattani was walking along behind John.
Right, Pope. We're nearly there.
That meant didn't quite dare.
I want to hear what the judge says at the end.
Brief recess, you may be seated.
All right, let's get the judge's decision. I'm sure it's here at some stage.
Remain seated. The defendant remain standing, please. Thank you.
Aidan Carney, after a bench trial, you have been found not guilty as to one charge of violate abuse prevention order. Such charge will automatically be sealed by the Office of Commissioner of Probation and the clerk's office, unless you notify both offices in writing within 10 days that you do not want the charge sealed, using the request not to seal court record. The request not to seal form must be sent to the Office of the Commissioner by mail or email to the addresses provided on the form. If you want copies of any documents associated with these charges, you must request them immediately before the charges are sealed. Thank you.
Thank you, Madam Clerk. Thank you very much.
Thank you, Your Honor.
Is that it?
All rise. Court says it is anything, please quietly. Thank you.
I was expecting the judge to say something, but no. Man, it would take him forever. I was expecting to hear something from the judge. I wanted to hear his opinion on what Gattani did and, you know, all the reasoning behind it and blah, blah, blah. But no, we didn't get nothing. We got nothing. Well, I think I have to end the stream, guys, because I'm getting hot. I'm overheating here, which I'm not supposed to be doing on a brand new logic board. Things shouldn't be getting hot. Leastways, not in the freaking middle of winter, like it's freaking icy cold here. So I think that's it. We shall tune in tomorrow, I guess. I have a feeling we are going to get a verdict. Like, I feel like they were close today. And I think that maybe Judge Bev threw some spanners in the works to make sure it didn't happen today. So we'll see. Everyone have a great night. Sorry, I got my mouth full. Trying to eat breakfast while I'm talking to you. I'm sure it's night time over there. Have a great night, evening, whatever it is. And we'll book another one if it looks like we're going to have a verdict tomorrow. And do it again. Talk to you soon. Be good, everyone. Sleep tight, Shell.